for you.
Okay, good morning. We're going to call the meeting to order. This is the Police Policy Committee meeting. It is August 22nd at about 10 a.m. We are in the boardroom of DPSST in Salem, Oregon. I'll do the administrative announcement real quick. Police Policy Committee administrative announcement. This is a public meeting subject to public meeting law. It will be digitally recorded. Deliberation of issues will only be conducted by the Police Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. We will start with introductions. And before we do, I think we have a couple new members, and one is not here yet. Patricia Lofgren is a new public member. She's not here. And then we also have a new person online. Megan Townsend is non-management law enforcement. And if you want to start with we'll go backwards this time. We'll have Megan start. Just tell us where you work, and then we'll do introductions online first.
Hi there, good morning. My name is Megan Townsend. I'm a detective with Hillsborough Police, and I am a representative from OPOA, the Oregon Peace Officers Association.
Okay, thank you. You want to do roll call?
Yes, of course. When I call on you, please state your name and who you're representing for the record, please. Chair Nowning.
I'm here, and I'm non-management law enforcement.
Vice Chair Cotting.
Casey Cotting, Oregon State Police.
Member Anderson.
Shannon Anderson, Oregon Association Chiefs of Police.
And then Member Barrett.
Denisha Barrett, Beaverton Police, non-management law enforcement.
Member Brandenburg is not present. Member Sarek.
Anel Sarek, Washington Sheriff's Office, and non-management law enforcement.
Member Dresser. Member Dresser, are you still with us? All right, and then now for Member Gardner.
Alex Gardner, OSP Command Staff Representative.
Member Lofgren is also not present right now. And Member Rowan.
Barry Rowan, Umatilla County Sheriff's Office, representing Oregon State Sheriff's Association.
And we already heard from Member Townsend, and then Member Wood.
Robert Wood, representing the public.
And we have quorum. And now for staff introductions.
One we're missing, Member Daniel.
Oh, sorry, Member Daniel, please proceed.
Mark Daniel, representing Oregon Association Chiefs of Police.
Perfect. And now time for staff introductions. I'll go first. Juan Lopez, Executive Assistant, DPSST, and then we can proceed to my left.
Shelby Wright, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST.
Jennifer Lavario, Professional Standards Compliance Coordinator, DPSST.
Phil Castle, DPSST.
Kathy Fink, DPSST.
Kath McAlpine, DPSST.
Jennifer Howell, DPSST.
Sam Tangy, DPSST.
Patrick Van Orden, DPSST.
Isabel Fox, Gainesville Journal.
All right, thank you. Before we get started, last time I think we used a little bit new format. That's now officially been adopted by all the committees. A couple of changes that I just want to remind you of. Instead of voting on some things, we're going to ask for a consensus. If we ask for a consensus, just give a thumbs up or a thumbs down. If you have an issue, a thumbs down, then we can address that. But if you are in agreement and consensus on the items that require a consensus, just give some sort of indication that you agree. And with that, has everyone had a chance to review the minutes from the previous meeting? So this will be the part where you say, yes, thumbs up.
Yeah.
And if there are no requests for modifications, this is where we will look for a consensus to confirm the meeting minutes. Love it.
Oh, yeah.
Oh, we're gonna have fun with this, I can tell. And I'm looking online. You can do the same as online as well. Just nod your head or give the thumbs up or some indication that you're okay. All right, awesome, thanks. Okay, so we will, I guess, look for we just,
The administrative closures, yeah.
but we're okay, we don't have to do
Yeah,
anything, no motions, nothing. Okay,
No.
so we have a consensus for that. Okay, so now we're gonna move to, we'll turn it over to the professional standards case manager, Jennifer, for the administrative closures.
Thank you. Jennifer Lavario for the record. The department may recommend administrative closure of discretionary professional standards cases to a policy committee when the department determines that the conduct being reviewed does not meet the statutory and administrative rule requirements for denial of notification. By motion, discussion, and vote, the committee members shall approve or return the department's recommendations of administrative closures for the individuals named on your consent agenda. Chair Downey.
Thank you. Do we have any discussion on any of the 4 cases on the consent agenda? Is there any recommendation that any of them need removed from the consent agenda? Okay, hearing none, I need a call for a motion to approve the consent agenda as it's been presented.
Rob Wood for the record. I'll make a motion to approve the consent agenda. Mark Daniel for the record. Second.
All right, we are voting on a motion to approve the administrative closures. Chair Nani?
Aye.
Vice Chair Cotton?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Okay, we're gonna move to the professional standard case reviews. Just for the folks in the room, we're not gonna quite go in order that was on our agenda because we have some folks here to testify. So we are going to start with Evan Wallace.
That'll be book 2, the last case in book 2.
Yeah. He's in the lobby.
And I think we have 3 folks testifying today. Will be Evan, Rachel will be going next, and Tyler Whitley will be third.
And
then
of course, each of them are in different books, so
Right.
I'll shout it out for you.
Thank you.
Member Loughran, thanks for getting here.
Yes.
Just so you know, we're going out of order, so we'll be working on Mr. Wallace, which will be book 2, last case.
Okay, thank you.
You're welcome.
Sorry, traffic was horrible.
Completely understand.
Good morning. I'm Scotty Nowling. I'm the chair of the Police Policy Committee. This is your opportunity to provide mitigation to the Policy Committee as we review your case. You'll have 5 minutes, exactly 5 minutes, to provide verbal mitigation. At the end, we won't be able to ask you any questions, and you cannot ask us any questions. Jennifer Lavario has a timer in front of her. Does it warn when it's close? Or not, just goes off?
No, it doesn't
Okay,
warn.
right. So just keep an eye on that. I will stop you at 5 minutes, okay? And when you're done, you can either sit at the table or you can take a chair on the back wall, whichever you're more comfortable with. Okay. All right, go ahead and begin.
Oh, no,
Sorry.
Jennifer, present the case.
Yeah, sorry. That's
I'll provide the state on this.
You do that, yes.
Okay. Case before you is for Evan Wallace. As you can see, he's here. The department opened a professional standards review after Evan Wallace resigned from the Tillamook County Sheriff's Office on February 4th of 2022 while he's under investigation for misconduct related to a game complaint investigation conducted by the Oregon State Police. Mr. Wallace was dishonest, TCSO found that with, Mr. Wallace was dishonest with the OSP during the initial investigation and was issued 2 criminal citations as a result of the investigation, exceeding the daily limit of fish and failure to immediately validate a harvest card, both Class A misdemeanors. Neither of the citations resulted in charges being brought by the Tillamook County District Attorney. However, Mr. Wallace was placed on the Brady list. The department's review determined that Mr. Wallace did violate the board's moral fitness standards as follows. Mr. Wallace was intentionally dishonest when he misrepresented the truth and attempted to deceive the Oregon State Police troopers who were investigating game complaint. Mr. Wallace was issued 2 criminal citations for game violations and was dishonest during the investigation of the violations and threatened the efficient operations of the Oregon State Police investigation and harmed the reputation of the Tillamook County Sheriff's Office and the police profession. Chair now. I'm sorry, that's my turn. It's my turn.
Not alone.
Okay. Mr. Wallace, are you prepared?
Yeah.
Okay. Go ahead.
All right. We won't take the full 5 minutes again. I'm Evan Wallace, obviously. First, I want to say thank you for the opportunity to come and speak and to be able to write a letter, which I'm sure some of you have read or will read. I didn't think I would get this opportunity to do this. It's been a few years, and so this kind of came as a surprise. The main reason I decided to come and speak in person today was basically just to put a face to the name on paper. I think it's important to show up for these kind of things in person, in my opinion. And most of my thoughts are in that letter that I wrote. And if you've read it, you understand what I would say in this. So I'm going to save some time here and just skip to the main reason I'm here is since you read the letter, the only things I really want to do and say are that I truly am sorry for what I did and apologize for the trouble and embarrassment I brought to not only my old department, but to DPSST and law enforcement as a whole. There's no excuse for my actions, like I said in my letter, and at this point I'd rather fall on my own sword than to make any excuses for what I did. I know in my letter I said I'm a different person and now, maybe, and there's no way to show that, but this experience has changed my life a lot, and no matter the outcome of this case, it's, ultimately I'm a better person because of it. Again, that's all I have to say, so thank you for your time.
Thank you. Okay, we're now going to ask for a consensus to adopt the record or return it to staff. Is everyone okay adopting the record as it was presented?
He voted twice.
This one takes a vote.
This one takes a vote?
Yeah.
This one does take a vote.
Yes. We need a firm modifier negate.
I'm sorry, Ms. Cowboy. Adopting the record is consensus.
I think I have an old cheat sheet. Thank you. Disregard Chair, you are doing a fine job.
I think you have my back, Jennifer. Okay, back to the thumbs up. And online, make sure that you're indicating some way. If you're online, please indicate some way that you're in consensus with us, either with a thumbs up or if you're on camera, nod your head. Okay, if there's no objections, I'm going to, looks like there's a consensus to adopt the record. Now we'll open up discussion for aggravating and mitigating factors. So we're going to open the case for discussion. Just a reminder to state your name and identify if you're discussing an aggravating or mitigating factor. Discussion is open.
Well, Alex Gardner, for the record, I'll state the obvious. It's aggravating that he repeatedly lied, and that when he started to come clean, he only came partially clean. and then he eventually fully owned it. And I'll say that it's not mitigating to me that a computer failure prevented proof of the fact that the fish were not timely tagged. Obviously, they weren't. They were sitting on the bank for a period of time, so he is fortunate that the case was not prosecuted in Tillamook County, because there would have been fishing license consequences and then some for this. On the mitigation side, I do appreciate the fact that he eventually owned it, and he showed contrition.
Thank you.
Connie will add for the record that his presence here today and testimony is mitigating.
Anyone else? Anyone online have aggravating or mitigating comments they want to make? Put on the record? If there's no further discussion, Jennifer, do you want to review what the aggravating and mitigating we've talked about?
Sure thing. For aggravating, I have that he repeatedly lied, and the first time that he did tell the truth, he only provided partial truth, and then finally he did fully admit, but it took a while for him to get to that point. That it wasn't actually mitigating in the report that there was a computer error, that the conduct really was kind of overruled that mitigating piece in the report. Mitigating was, though, that he eventually did own and showed contrition for his conduct, and his presence and testimony here today are mitigating.
Thank you. We need a consensus that Jennifer has captured the mitigating and aggravating circumstances that we discussed. Okay, appears we have a consensus. We now need to open the discussion of whether there was a moral fitness violation. We have the following options for moral fitness findings. We can affirm, that means accept the moral fitness findings as they were presented. We can modify them, make changes, or we can negate them and remove them all. And so this would be the point where we call for a motion to do one of those three: affirm, modify, or negate.
Question for you, Chair. Do we take them individually, or do we take the dishonesty separate from the misconduct?
We could certainly have a discussion. If you want to modify it, then we would, so they have presented, DPSST has done the review and they have presented it to us. So if you think something needs modified, then I think we would discuss that or make a motion to modify it. If we want to accept as they are presented, then we would do that. If we do modify that, then I believe once we come to an agreement on modifying it, then we would take a vote. If that makes sense.
Alex Gardner, for the record, I move that we accept the allegations, affirm the allegations as alleged.
Kevin Dresser, for the record, I second that.
Thank you.
Right, we are voting on a motion to affirm the moral fitness violations. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren? Aye. Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
We now need to call for a motion to either take action or take no action.
Kevin Dresser, for the record, I recommend we take action.
Barrett, I would second.
Thank you.
All right, voting on a motion to take action, Chair Nani,
Aye.
Vice Chair Cotting,
Aye.
Committee Member Anderson,
Aye.
Committee Member Barrett,
Aye.
Committee Member Sarek,
Aye.
Committee Member Daniel,
Aye.
Committee Member Dresser,
Aye.
Committee Member Gardner,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan,
Aye.
Committee Member Townsend,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
We'll now have a discussion, and we'll be looking for a motion regarding the amount of time of ineligibility this person will be facing. And just a reminder, if you are looking for a motion for a specific time, go ahead and explain why that time would be appropriate. If it's misconduct and misuse of authority, it's 3 to 10 years is our window we can use. Dishonesty and discriminatory conduct is 3 years to a lifetime. We can open that for discussion now. And or a motion.
And Rob Wood, for the record, question for staff, because I see it in other cases and not this one. When does that period of revocation begin?
Jennifer Lavario, for the record. His would be the date of separation, which is February 4th of 2022.
Thanks.
Kevin Dresser, for the record. I mean, my initial thought is 3 years based on totality of the circumstances. I guess the lie is a lie, but his letter plus his somewhat quickly he tried to come back around with the truth. I think, at least from my opinion, kind of that matches the 3 year versus a 10-year or lifetime.
Okay.
Barrett,
Go ahead.
Barrett, for the record, I was somewhere more in probably the 7-year mark. I would agree with Kevin under the totality of the circumstances regarding what he was arrested for. But to Major Gardner's points, the level of lies that were taking place, how many he told, the fact that he hid them, went back under the cover of darkness to pick them up. I think at one point he even blamed somebody else. That just shows a pattern, and a pattern around something that could seem so minor is a little bit bothersome, regardless of the severity of the crime that we're talking about.
Thank you. Any other discussion, or does someone want to make a motion for an actual amount of time?
Alex Gardner, for the record. I'd recommend 5 years. That's not just splitting the difference, but for me, the severity of the offense that he avoided sort of cuts both ways. It cuts against him in that the potential consequences were very low on the scale of things. And so I guess the argument would be, if he's willing to lie when the consequences are low, what about when he's looking at $100,000 in the back of a car, So because of that, I think it needs to be more than 3 years. As a practical matter, he's unemployable for the foreseeable future because he's on the Brady list. And that'll be circulated. So for those reasons, I believe that 5 years is appropriate. Maybe he can recover over that period of time.
Okay, and that's your motion for 5 years?
That's my motion. 5
Okay,
years.
do we have a second for that?
Shannon Anderson, I second that.
All right, we are voting on a motion for a 5-year ineligibility period. Chair Nownie?
Aye.
Vice Chair Conning?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek? Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan,
Aye.
Committee Member Townsend,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
Thank you very much.
I think Denisha got 2 cases, but,
Go to Bo9.
yeah, we can blame it. Right. We're a little rusty on that. Oh, I missed rusty.
You're doing good. I had to have the
His
right
father.
cheat sheet too to help you out. I failed in that regard, sorry.
I was like, man, where's the fire?
Yeah.
All right, which
O9,
Yeah, Rachel, Bo9 is next.
book 1, first case passed the administrative closures.
That's right, thank you.
Remember, someone has to talk during these. Thank you, thank you.
They have it covered.
Which one?
Boning, first book. No, I'm sure. Prepared for so many other notes. But I don't trust them sometimes because I just you know, you're seeing somewhere that point one. Especially when I paired on that. I mean, and it's almost not standard, you know, that's the thing. And there's not, you don't get this on everything. You're like, that's just. Yeah. But, you know, this is at least some sort of objective. View of and then there's another level up of this if we disagree, so that's where I just don't put a ton of weight. Okay, back to where I was supposed to be here.
First one.
Hello. My name is Scotty Nine. I'm the chair of the Police Policy Committee. Once your case is presented, you're going to have an opportunity to provide verbal mitigation, and that will be capped at 5 minutes. And Jennifer has a timer over there. At the end of your 5 minutes, I will stop you, just to be fair to everyone else. We won't be able to ask any questions, and you can't ask us any questions. When you're done, you can sit at the table if you feel comfortable, or you can take one of the chairs in the back. And then when we're totally done with your case, you can just exit out the side door.
Jennifer Lavario for the record. The department opened a professional standards review after Rachel Bo9 resigned from the Lake County Sheriff's Office while under an internal review for multiple incomplete misconduct investigations. The Oregon State Police was asked to conduct a criminal investigation, which resulted in no charges being brought against her. There were, however, numerous neglected citations and arrests that were either neglected altogether or not promptly resulting in dropped charges and delaying the prosecution of others. Meanwhile, on August 12th of 2022, Ms. Bo9 received a criminal citation for assault in the 4th degree, recklessly endangering another person, and maintaining a dangerous dog, all Class A misdemeanors. Ms. Bo9's dog bit without provocation a patron of the watering hole at Fort Rock, causing an injury to the patron's arm and hand that required medical attention. Ms. Bo9 entered a plea of not guilty to all 3 charges. On March 9th of 2023, the court removed all 3 charges, and Ms. Bo9 entered into a civil compromise that added a violation of maintaining a dog that is a public nuisance, a Class B violation. Ms. Bo9 entered a plea of guilty and was convicted. She stipulated that any future act by the dog would require forfeiture of the dog to the Lake County Sheriff's Office, and she was ordered to pay $1,300 to the Lakeview Animal Hospital related to impound fees. The department's review determined Ms. Bo9 did violate the board's moral fitness standards as follows. Ms. Bo9 harmed the efficient operations of the Lake County Sheriff's Office by neglecting to act upon 11 citations and 4 arrests promptly or at all, resulting in charges being dropped and delaying the prosecution of others. Ms. Bo9 violated criminal law by being convicted of maintaining a dog that is a public nuisance and bringing harm to another who encountered her dog. Are you prepared? Just start again.
My name's Rachel Bonine. I graduated with BP 367 in June of 2017. I was a deputy and a canine handler with the Lake County Sheriff's Office. In June 7th of 2018, I was on days off when I received a call out from dispatch. The call was a 13-year-old gunshot wound victim with CPR in progress. On my way to the call, I found out that the victim was the son of some close friends. I considered them like family to me. The victim was declared deceased a short time later. I worked with the state police through the night and into the next morning. I went home and slept for 2 hours, then returned to work a full shift. I attended one debrief with EMS and one from LCSO, and that was the last of the support offered by the agency. A couple months later, I experienced a critical stress level, so I reached out to one of the CIT members who directed me to a counselor. I began counseling and continued through my employment with the agency. I had not requested assistance from the Sheriff's Office because I felt that I did not have mental health support from the agency. Throughout the next 3 years, I experienced at least 5 other critical incidents involving people I know personally. March of 2021, I wrote the sheriff a letter voicing concerns of his lack of support and leadership for myself and my fellow deputies. In the letter, I referenced a video from a county commissioners meeting where I felt the sheriff was disparaging the deputies, to include myself. Upon receiving the letter, the sheriff sent me an email stating he wanted to know who sent me the video in question. I responded with the link to the newspaper's webpage. I refused to disclose the identity of the person in question because I feared of retaliation against them. The sheriff then told me that I could voluntarily comply with his request or he would be opening an investigation and later threatened disciplinary action if I did not comply. I contacted my union rep, and after intervention from my rep, the sheriff ceased but said that if I failed to follow any directive from him in the future, he would fire me. October of 2021, prior to my vacation, I had a phone conversation with the sheriff in which I told him I knew I was behind on reports, but I was struggling. The sheriff told me to go on vacation and then said, quote unquote, keep your head up, kiddo. First day back, I received a call from my union rep telling me that the sheriff was placing me under investigation for delinquent reports and poor work performance and intended to suspend me. I worked my shift, but then made the decision to go on stress leave. I resigned May 30th of 2022 because I felt that the work environment would not be constructive and I felt like I needed to protect myself from any further retaliation. August 2nd of 2022, I received a call from OSP Detective Callahan, who had been forwarded the personnel investigation, and after conclusion, I was informed that it was deemed unfounded and there was no further action. August 12th, after my dog bite incident, report was taken by Deputy Lance Brown. I signed a voluntary quarantine form and answered the questions from the dog bite report. Later that night, at the direction of Sheriff Taylor, Deputies Brown and Alvarado came to my residence to seize my dog under county ordinance. I was advised that if I did not relinquish my dog, I was going to be arrested. In my career, I never saw a dog bite case handled in this manner. I was told that the sheriff and the DA had a position of addressing my case in this manner due to my dog's prior bite history as a police canine. After 13 months, I was able to get my dog back after a civil trial. Regardless of all of this information, I am and have been willing throughout all of this to take responsibility for the things that I am responsible for. I do believe that I could have done better as a police officer. I should have taken the initiative to seek training and assistance, even if that meant going outside the agency to do so. I take responsibility for my dog biting my neighbor. I should not have taken him into a public venue. With that being said, I do hope that consideration can be given to the extenuating circumstances around my career as a deputy and the events after. Since then, I have obtained certification as an EMT, being licensed nationally and on the state level. I have been employed with the Lake Health District since June of 2022. While I enjoy the work and I can serve the community in this capacity, it's not been the same for me. Working as a police officer, I felt like I had found my true passion. At no point during my career did I do things to intentionally ignore the cases I was investigating. I was under an immense amount of stress and did not know how to manage the stress properly. I've gained valuable knowledge to understand myself better and how to manage the inherent stresses associated with being a police officer, and I do believe that I can return to law enforcement and be an asset to an agency. Thank you.
We're going to be asking for a consensus to adopt the record or return it to staff if additional information is needed. And maybe I'll have a question for staff. Some of these, some of the citations and things, to me at least, it wasn't necessarily clear. Were they half-completed citations that were not? I know there was a couple of them that did seem to be attached to cases, to others. I didn't seem like I had enough information. I didn't know if there was. I'm assuming there was no more information, or we would have got it. Okay. Yeah, because I was having trouble. Like, okay, is this a site that someone started to write and then didn't finish it or messed it up and put it in or is this an actual case that no one turned in? So I don't know if anyone else said the same, but if there's no more information, there's no information.
Jennifer Memorial.
Member Townsend had a question. For the record, there was a letter mentioned to the sheriff that was written, and so I was curious if that was in the materials. I may have missed that. If that's something that we might be able to see, or if there was a response from the sheriff. I think that was written in 2021.
Jennifer Memorial for the record. I don't believe that was part of the records that you received, nor did I receive, as well as your question, Chair Nowning, about the citations. They were not part of the original documents I received as part of the request. However, they are things that I could reach out for if the committee would like to have done.
Okay. More discussion on any of those?
Kevin Dresser for the record. I kind of agree, maybe more clarity on, like you said, where these citations just, they weren't filled out correctly and those were second copies or whatever. I understand some of these cases were dismissed and stuff, but there's a little gray area there. And then, yeah, maybe seeing the letter to the sheriff, and if there was an email response or formal response in writing that we could look at, might be worth looking at.
Rob Wood for the record. There is a statement from the OSP that there was not an intent and it didn't benefit or harm others. So someone has done an investigation, we just don't have that information. Is it our job or is it the investigator's job? Well, is it the investigation's job to prove a moral fitness violation? I would say yes. And if we don't have that information, then does that responsibility fall on us as the committee members?
Alex Gardner for the record. I know that we can send the case back and ask for more investigation before we ask for the staff to do that, since they already have a lot on their plate. I'd want to have some discussion about whether that has any chance of turning our result. I'm not quite sure how to phrase that, but those elements aren't essential to the decision making in this case for me.
Mark Daniel for the record. I agree with Member Gardner.
And Shannon Anderson, I also agree.
Okay. Let's talk about, I guess we can talk about aggravated mitigating. If we get to the end and we get to the point where we do feel that, we can always go back and send it back, correct? We can undo something we do. Yes, okay. So let's just go through, see where we end up. And if it does get to a point where we can't come to a decision because we think we might need more information, we can go back.
So Alex Gardner for the record, as to the misconduct, one of the allegations is that she violated criminal law by being convicted of maintaining a dog. It was not a criminal law. She was convicted of a violation, which is significant.
Yeah, and Scotty Downing for the record, for mitigation, it seemed that, not that everyone was doing it, so she did it, but it did seem like bringing dogs into this establishment was something that was common, and I know those things are different in small towns sometimes. Everyone knows everyone. She did take responsibility, didn't deny it, offered, I think she drove to pick the person up from the hospital, offered to pay the medical bills, and so those are all mitigating for that part of it. It wasn't as if there was some rampant dog running around, attacking people. It was an unfortunate incident that could have been prevented, but it did seem like she took responsibility, so that's mitigating for me.
Rob Wood for the record. I don't have enough information to show a moral fitness violation on the citations and things, and that's back to my original question, which Alex, thanks for clarifying it for me. I don't think it's our job to do that, so saying that, I think the mitigating factor is these are performance issues. What caused the performance issues? That's, I think, not material to me. And so mitigating factors is, I don't think there's enough information in here for me to sustain a misconduct.
Shannon Anderson, I agree that these were performance issues. I do believe that there is some mitigating factors in that as an agency, when we know that our folks have gone through experiences and they're reporting to us that they need assistance. We do have some, we should take care of our folks so that they can go out and take care of the community in an effective and safe, moral way. So that is mitigating for me. I think that when I look back at that time, we were just starting to, as a profession, be better about this. And there was a lot of unknowns. And there is the opportunity that it may not have been handled well.
Anyone online have anything? Aggravating, mitigating?
Barrett, for the record, I would add under mitigating, that OSP did do a comprehensive report regarding this and kind of deemed this all up to administrative concerns, of which were handled at the agency level appropriately. I would agree that definitely some poor performance, likely brought on by stress, some vicarious trauma, and some workplace hostility. But I do not think that this rises to the level of board action. I know we're not there yet, but I'll voice my opinion now.
Okay, did you want to review our aggravating and mitigating?
That this was not a criminal law conviction. Bringing dogs into an establishment wasn't really reckless or dangerous type conduct. She took responsibility for it. But these are performance issues. These are all mitigating, by the way. There's not enough information in the report and the records obtained in the report to sustain misconduct. That the profession should take care of its own officers who have to go out into the community into these stressful situations, and that OSP did do a comprehensive report and deemed it to be an administrative decision, and it was handled in-house appropriately.
We're looking for a consensus that Jennifer has captured our only mitigating. So, head nod or thumbs up or something if you're online. It's great, thank you. Okay, I believe we have come to a consensus. We are going to now move on to discussion about moral fitness violation categories. We need to affirm, accept as it is, and in this case, there's only a misconduct finding. We either affirm it, modify it, or negate it.
Rob Wood, for the record, I make a motion that we negate the misconduct. Moral fitness violation.
Can you maybe just explain a little bit for the record so we can get a record? You want to negate it, but
I want to negate it based on I don't think there was a misconduct violation that occurred.
Okay.
Is that what you're looking for?
Well, I mean, your thoughts of why it's not a misconduct violation. We're just trying to
For
make a
all
good
the
record.
mitigating reasons we brought up. I think it was performance based.
Okay. Other discussion about that? I mean, I think one thing that's important too is she did have 3 letters, but there was never a performance improvement plan that was shown to us, which it seems like if a person is having the same thing, you can keep writing them up or you can put them on some sort of plan to correct the problem, and it didn't seem like that was done. So that kind of weighed heavy on my decision as well, that this was a performance issue that doesn't seem like it was appropriately addressed. And the dog thing is seems like it, in hindsight, probably should have brought her to the bar, but it's something that can happen and she took responsibility. So you have made a motion to negate. Someone seconded.
Conning, second.
Okay.
All right, well, we are voting on a motion to negate the moral fitness violation. Chair Nowney?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson? Aye. Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you. So we don't need to move on.
Nope, we are done.
Okay. Thank you.
This will be Whitley, Book 3, third case. Well done, Chair.
Move it along. Sorry to be pushy, but I think if a future board looks back at why we did what we did, even though we all kind of have a tacit understanding what we're doing, I think it's important we say it so someone can read it. You're on report. Rob, you're on report. Whatever that means. We're book 2, you said book 2, right?
Whitley is Book 3, third case.
You seem to just know them, so it's good. It's like hot in here, man.
Negative.
It's warm in here. Right? It is warm in here. Okay, all right. We have AC, you guys not put the AC bill?
It's warmer than normal.
It's what?
It's warmer than normal.
It's hot in here, right? Oh, yes. Oh,
It's not getting down yet.
well, let's turn it on.
Cool.
Of course you are.
You're wearing lighter body armor.
True. That's fair.
Good morning. My name is Scotty Downing, the chair of the Police Policy Committee. Once your case is introduced, you'll have an opportunity to provide a mitigating statement, and that will last 5 minutes exactly. I will stop you after 5 minutes. At the end, you will not be able to ask us any questions, and we won't be able to ask you any questions. We will then discuss the case, at which time you can sit at the table, or you can sit in the back, wherever you're comfortable. And then when we're completed with your case, you can just exit out the side door. Appreciate it. And Jennifer will present the case, and then she'll let you know when it's time for your mitigation.
Understood, thank you.
Thank you.
Jennifer Lamoria, for the record. The department opened a professional standards review after Mr. Whiteley, is it
Whiteley, correct.
resigned from the Washington County Sheriff's Officer while under investigation for policy violations after a complaint was filed alleging he was under the influence of intoxicants while on duty. The complainant noticed an odor of alcohol from Mr. Whiteley while sitting at a day shift briefing. Per Washington County Sheriff's Office policy, Whiteley provided a breath sample which read 0.058% blood alcohol content, and he was asked to report home. An investigation was not completed prior to Mr. Whiteley's resignation. However, the investigation cited Oregon administrative rule defining being impaired to a noticeable and perceptible degree on duty as having a BAC above 0.02%, and that termination was the presumptive sanction for such a finding. The department's review determined that Mr. Whiteley did violate the board's moral fitness standards as follows. Mr. Whiteley harmed the efficient operations of the Washington County Sheriff's Office by reporting to duty while under the influence of alcohol in violation of Oregon administrative rules. Mr. Whiteley's conduct threatened to harm others when he provided a 0.058% blood alcohol content sample while on duty, which is over 2 times the definition of impairment on duty as defined in Oregon administrative rules. Are you ready, Mr. Whiteley?
I'm ready. Morning, thank you for your time. I was down at this campus, 2011 is when I had a basic police academy, and I was class leader. I graduated with the Victor Giattia Award and very, very enthusiastically went into a career in law enforcement. Had a lot of success, mental health response team, crisis negotiator. Somewhere along the line, I made the poor decision of alcohol became my coping mechanism, but never to a point where it impaired my ability to work. And at the time of this incident, I was on light duty for a work-related injury that was still being debated whether it was going to be covered by workers' comp insurance or not. I had a particularly bad day at work with bad news after bad news after bad news, both personal and professional. And I went home that night, and after dinner, I started drinking and continued drinking. And I think, not that it's an excuse, but I think the fact that I knew that I was on light duty and I would not be armed, I would not be in a patrol car, that I made it okay in my mind that I could go to work with a hangover. It was never my intent to actually have a BAC of any kind the following day, but that was my mistake. And obviously, when I was placed on admin leave, I had to acknowledge the fact that alcohol had affected me personally and professionally, and I had to make some decisions about what I was going to do about it. And almost immediately, I reached out to a certified drug and alcohol counselor and began counseling with this individual. And the first step was to come up with alternative coping mechanisms, alternative routines, things to do instead of just pour and drink, which I have successfully implemented in my life, which has been huge for me. The second thing is he gave me a formal diagnosis of chronic PTSD, and he strongly encouraged me to consider changing careers, which I was not good with at first when he made that recommendation, because I didn't know what else I would do. This is what I do, this is who I am. My wife is a mental health professional, and it was really conversations with her that started to make me think about, do I want to continue in this career? Do I want more years of retirement with her? And I had to acknowledge that this job had taken a toll on me physically, mentally. And I fully intended to go to my discipline hearing, go through the process. I think you have several character letters that I had coworkers write for me that I had ready to take to my discipline hearing. I had no intent of not going through with it. And it was some really difficult conversations with my wife, kind of over the Christmas holidays, that she was concerned. And she said, I think you should just rip the Band-Aid off. And I said, what am I gonna do? And she said, we'll figure it out, but for the sake of your mental, emotional, and physical health, and for the sake of our family, she's like, I think we should figure out something else, and I think you should not do this. And we made the decision right around New Year that I would, first day of the new year, 2023, I would submit my resignation. Since then, I have been leading a different lifestyle. I am currently employed with Oregon Department of Human Services with Adult Protective Services as a complex case investigator with APS Central. I love my work. I love the fact that I get to use all my skills that I've acquired over the years as an investigator, but I can do it in an environment where I'm not wearing body armor, I'm not carrying a gun, and I would just ask that the committee would take into consideration the steps that I took immediately to make changes in my life. And one of those was to leave law enforcement. And that was a really hard decision for me. And I still don't think of it as a permanent decision, but it's something that I think in the time being that I needed to do. And I appreciate your time, and that's all I had to say.
Thank you. Okay, I'll ask for consensus to adopt the record or return it for more information if needed. Do we have discussion or a consensus about the record? Adopt the record. Okay, looks like we have a consensus to adopt the record. Any objections to adopting the record? Hearing none, we will move forward to discuss aggravating and mitigating factors. Just a reminder to state your name.
Shannon Anderson. mitigating for me is my understanding that alcoholism is a disease, and there are behaviors that go with that disease, and being under the care of some type of professional and following through with that is mitigating for me.
Alex Gardner, for the record. It's also mitigating that at the time, although he was on duty, he wasn't armed engaging in enforcement or subject to deployment to engage in enforcement.
Kevin Dresser, for the record. I think mitigating also is his, just the fact that other than the numbers, there is no signs of impairment while he was at work, from how he parked his vehicle to it was just simply the odor. And I think he provided some factual information and was quite surprised based on when he quit drinking the night before and what the numbers were the next day. But I think that the totality of circumstances with regard to being on a light duty assignment, not feeling the effects, not displaying any effects, kind of shows a lot also. Not to say also his response when confronted with it. He responded correctly the whole time and procedurally with regard to anything that was asked of him following the odor that was detected.
Thank you. I agree. Anything aggravating, mitigating, anyone wants to add?
Mark Daniel, for the record. I just want to agree with Detective Dresser. There was nothing here that indicated that anyone perceived him to be intoxicated at the time. It was an odor only, which caused the sergeant to bring him aside and then involve the second sergeant and subsequent blow. And there was certainly nothing noted with his parking of his vehicle behind the sheriff's office or any other type of impairment was included in this. The other mitigating fact for me was that he was upfront, he accepted it, he sought out some counseling and some diagnosis and tried to mitigate his own set of circumstances himself.
Thank you. If there's nothing else, you can go ahead and recap, Jennifer.
Actually,
okay.
One more note for the record, and maybe this is more of a question, but so Alex Gardner, for the record, it's not, if somebody is subject to deployment for enforcement action and they're under the influence, the risk of public harm is obvious. It's not clear to me what the potential risk to public harm was in this case if he's on light duty in the office. So that's part of the report that we'd be either accepting or negating. So I just wanted some clarity from the group on that.
Well, I think a little further down we'll discuss that and see whether we want to potentially negate that portion of it based on our discussion.
If we negate that, that would be part of the mitigation.
Kath McAlpin, for the record, in your packet, it does note what his responsibilities were, the types of duties under his light duty requirement. And if I can find it, or Jennifer Lavaro can find it, we can call it out if that's helpful. In the staff report,
it's it's on page 2 of 4, where it starts out Whitley interview.
Yeah, public demand calls that would be handled by phone, writing reports, handling the tip line, writing search warrants, and other police type work.
Understood. It's just, I guess I'll just leave it on the table, but typically when there's search warrant writing, it's subject to review. I'm not trying to diminish the conduct. I'm trying to sort of assess the actual potential for public harm. Not many people write search warrants that aren't subject to other review. So
Shannon Anderson, I think what I hear is that maybe the checks and balances involved in that work are mitigating.
Rob Wood, for the record though, couldn't we argue that answering the phones, taking tip lines would not be subject to review with that initial interaction with the public? So technically, there could be some harm?
Yes, but could be, wouldn't be the standard, and there's no evidence that he was actually, that his function was in any way impaired. It was, they noticed an odor of alcohol. So before making a finding that he was, putting the public at risk, I'm just uncomfortable with it. I'm looking for you all to persuade me.
My understanding, Connie, for the record, is that this was stopped before he was engaged with the public. So this was a briefing at the beginning of the shift, so I don't know that that harm had it occurred or could occur.
That's
Scotty Downing from the record. If you were driving and you only smelled the odor, and you didn't have these other things, if you didn't have other indicators of impairment, and they blew a 058, would not be necessarily a crime. It's under the legal limit for driving, and so you would have to be articulating things that you actually see. And so driving is clearly one of the more dangerous things you can do, and this would not be. I understand it is the OAR and it's the rule, but if we're talking about actual harm, and just looking at something very similar where they take a blood alcohol measurement, the state law is 0.08, unless you've seen, obviously, if you have cues of impairment.
Alex Gardner, for the record, if ever there was going to be an observation of impairment, it would be in the sea of cops. He's in a cop house. So, based on the fact that they didn't note impairment and Superintendent Cotting's observation, I would say that it's mitigating, that there was no actual risk to the public.
Are we ready now to, is it what everyone said what they need to say, aggravating, mitigating?
Shannon Anderson, in thinking about that though, I wonder, is that outcome-driven decisions because one individual noticed an odor, otherwise they would have gone and continued their work. But it was prevented because an individual noticed it. So I'm working through that in my mind, what that is and what that means.
Barrett, for the record, I would have to agree with just that point exactly. His actions or any possible negative or positive outcomes of this was cut off by an observant coworker doing their job, right? Duty to intercede and all that. So I would have to agree to that point specifically. And Barrett, for the record, while I have the microphone, I also found mitigating, he had a number of letters written by coworkers speaking to his character as a person, and I want that noted.
Okay, no other comments? Jennifer, if you want to recap?
Sure. I do have a couple of questions about some of the discussion when we were at aggravating, mitigating, but I'll get to those. Mitigating, alcoholism is a disease, the behaviors that go with it, and being under the care of a professional is mitigating. He wasn't armed or subject to deployment at the time, had no signs of impairment other than BAC. The totality of the circumstances, not feeling or showing the effects of being under the influence, and his response to finding out what his BAC was appropriate. There was odor and nothing else. These are all along the same lines. His parking was appropriate. He accepted and sought counseling on his own. The checks and balances in the work environment were mitigating. 0.058% is not a crime if he was driving. Those around him, the other officers around him, didn't see any signs. The number of letters written speaking of his character were all mitigating. Now, on the aggravating side, I'm not sure if there were aggravating. There was discussion about would interaction with the public or could that be threatening or aggravating? And I'll leave that up to you to tell me. And then the other was it was prevented, so is it aggravating that if it weren't prevented, something else could have occurred? And I'll allow the committee can tell me how they're following those.
That was your. I would probably describe it as fitting the way it's worded is that it threatened to harm. It doesn't say it did or didn't, it threatened, could have. So I think in this case, the fact that it was prevented is really neutral.
Neutral.
I wouldn't put it mitigating to, towards the misconduct.
Okay, we're looking for a consensus on the mainly mitigating discussion we've had. Does anyone need anything else, or we think we've covered it? Okay, appears we have a consensus. We will now open discussion on whether or not there is a moral fitness violation. We can either affirm, modify, or negate. In this case, it's the misconduct.
Rob Wood for the record. I think we could clarify this because I used the word could have. I'd like to revise it so Whiteley's conduct potentially threatened to harm others, but as we brought up, it was stopped. Nothing did happen. And it goes back to the ones that I was talking about that don't have checks and balances, interacting with the public at the counter, answering the phone, handling a tip line.
So you're requesting that the misconduct, just in the description of the misconduct, be modified?
That is correct.
Okay. Is that a motion?
If it needs a motion, that's a motion.
I think we need a motion to modify that, right? Or we could have more discussion about it and then.
God, I will second the language change.
We are voting on a motion to modify the moral fitness violations as discussed. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren? Aye. Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, so I think what we need to do now is, since it's been modified, we now need to have a motion to affirm the modified misconduct violation or negate it, I believe.
Okay, now I'll make a motion to affirm the revised misconduct violation.
That was Rob Wood for the record.
Rob Wood for the record.
Scotty Downing for the record, I'll second that. Nope.
Chair Downing, may I just clarify before we do that? So, leaving misconduct, the first sentence the way it is. The second sentence would be Mr. Whiteley's conduct potentially threatened to harm others, blah, blah, blah. Is that what I'm hearing?
That is what I
That was my
understood.
motion.
Yeah.
Okay.
And so the affirming vote now would be to leave that as I just said.
As you said, yes.
Thank you. Okay.
And Chair, just to confirm, the modifying is everybody's accepted as now presented, so now it's just whether or not there's action to be taken. So we don't have to take another vote, they've already said they agree with the modifying.
If you say so, I'm good. Okay. Okay, so now we need to have a discussion of whether or not we take action or take no action.
Alex Gardner, for the record, I move we take no action.
Rob Wood, for the record, I second.
And we need to say why we're not taking action. So if we're doing no action, we just need to have some discussion on why, for the record.
My motion is based on the fact that, on the mitigating factors that we've described and the fact that he's already taken responsible steps to mitigate the risk.
Thank you. And someone seconded, I'm sorry? Okay.
Right, we're voting on a motion to take no action. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek? Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lundgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Thank you.
Thank you.
Now we can go in order.
Okay. We're gonna go Stephen Mayberry next. So,
Book 2,
just to let
Yeah.
the vote taker know,
Absolutely.
so then I don't get voted. Before we start with this case, I'm recusing myself from this case, so I won't be voting. I was involved in representation of this employee during this incident. Go ahead. Oh,
You can still chair it though. Go, if you're ready to turn it over to Jennifer, that's great.
I was. She was ready to go. so
Okay,
I-
good. All
Go
right,
ahead.
I like it. Thank you, Jennifer Lavario, for the record. The department opened a professional standards review after Stephen Mayberry retired from the Salem Police Department while under investigation after a complaint he was using agency computers and confidential law enforcement databases to conduct inquiries for his personal gain and exhibiting stalking-like behaviors towards his ex-wife. Mr. Mayberry filed an unsubstantiated complaint against the complainant to her employer. The department's review determined that Mr. Mayberry did violate the board's moral fitness standards as follows. Dishonesty. Mr. Mayberry intentionally falsified a complaint against his ex-wife, the complainant, to her employer. Mr. Mayberry intentionally used his position while on duty as a public safety professional to access confidential law enforcement databases for personal gain to look up persons not associated with any business purpose in an effort to harm the complainant and her family and friends. Mr. Mayberry's use of confidential law enforcement databases to access information related to the complainant and not for legitimate business amounted to stalking, which harmed the complainant and her family and friends. Mr. Mayberry's filing of a false claim against the complainant to her employer caused harm to the complainant and her family. Chair now.
Thank you. We're looking for a consensus to adopt the record or return it to staff if needed for additional information. Consensus to adopt the record. It appears we have consensus. Is there any objections? Okay, let's open up for discussion of aggravating and mitigating factors.
I'll get it going. Rob Wood, for the record. To be frank, I can't find any mitigating factors. Nothing jumps out at me in any of the data that's mitigating. So aggravating, clear LEDS violations numerous times. And that's well known in the industry. I even know that as a public member, that he just never thought he'd get caught.
Thank you. Further discussion, aggravating, mitigating? Anyone online?
Member Townsend, for the record, it sounds like if he had remained employed there, he may have been investigated for a criminal domestic violence incident. So just wanted to add that for the record.
Thank you. Anyone else? Okay, Jennifer, you can review whenever you're ready.
Okay, I have no, mitigating circumstances, only aggravating, that there were numerous lead violations, which is obviously a confidentiality, violation, and that he never thought he would get caught. That if he had remained employed, he may have been investigated for criminal domestic violence.
Is there a consensus on those? Any objection to that? Okay, hearing none, let's open the discussion of whether or not there was a moral fitness violation. You can affirm, modify, or negate. And there is all three this time: dishonesty, misuse of authority, and misconduct in the findings.
Cotting, I'll make a motion that we affirm all three findings.
Shannon Anderson, I second that.
Discussion, Rob Wood for the record. On the dishonesty, I could not find anything in the data, unless you guys can point, I'd like you guys to point me to it, that there was proof that the complaint was falsified. And that's what the dishonesty is pointing to, where he filed a false complaint against. Can anyone show me where that is?
Kevin Dresser for the record. I think I kind of agreed. I think it mentioned it was kind of unfounded, but it didn't give specifics on their end as to, I mean, we don't have their investigation on their end based on his complaint.
Patty Lofgren, a public member. I'm looking at a page where she's speaking with, she's been asked into the office from HR, and that they have a record that she's been diverting drugs. And the allegations came from Steve Mayberry. LET, topical anesthetic, used to desensitize the skin, etc.
Robert, for the record, if my recollection is correct, that is true. And then, but he supplied photos of prescription drugs. I understand his intent was inappropriate, but again, I can't find the proof that it was intentional. That's why I'm bringing up the concern that I think it should be revised and remove the dishonesty portion of the moral fitness violations.
So, Cotting, for the record, I would remove my recommendation based off the discussion and Member Wood's notes on that.
Shannon Anderson, I agree. Second it.
A further point on that, Kevin Dresser, for the record, when they were looking at that, the vial that he found in the refrigerator is non-narcotic, And I remember there being a statement that would be, I don't know, similar to one of us going home with a traffic crayon in our pocket. You know, it's one of those things that a nurse working could easily walk out of the office at the end of the day with something like that. And it just doesn't rise to that level of stealing drugs or something like that, at least the way it was described in the report.
So it sounds like we want to modify and remove the dishonesty. Is that the motion that was made? And affirm the other two. So someone made a motion, I forget who.
Do I need to restate it?
I just want to clarify that what your motion was. What's it look like? You made a motion, I believe, to modify, which was remove dishonesty, but to affirm misuse of authority and misconduct.
That is correct.
And someone seconded that. I believe.
Kevin Dresser, I second it.
There we go. Okay.
All right, we are voting on a motion to modify the moral fitness violations as discussed. Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan? Committee Member Rowan?
I'm sorry, aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, we need a motion to take action or no action. If you are voting to take no action, please include why your recommendation to take no action.
Kevin Dresser for the record, I recommend we take action.
Alex Carter for the record, I second.
Thank you.
Voting on a motion to take action. Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Member Barrett accidentally left the meeting and she's not.
We were on you, Committee Member Barrett.
Sorry about that. I got kicked out. If you're waiting for an aye, I was definitely an aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, we now need a discussion and a motion regarding the amount of ineligibility, or the length of time for the ineligibility period. We are looking at 3 to 10 years.
Ken Mandy, or Rob Wood for the record, I recommend a full 10 years. Based on the egregiousness, the severity of what has transpired and happened in the record.
Mark Daniel for the record, I second.
All right, we are voting on a motion for a 10-year ineligibility period. Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay. I make a motion that we take a 5-minute break. Anyone else?
Second that.
You're the chair, you just do it. 5-minute break, real quick. If we're ready to get started again, we can get moving. We got a few more cases to go. 5, right? Yep. We are on case number 7 in your list, Nathaniel Medeiros. And are we on? We're good? Okay, go ahead, thank you.
Jennifer Navarro for the record. The department opened a professional standards review after receiving information that Nathaniel Medeiros was criminally cited and charged with 3 counts of taking, angling, hunting, or trapping in violation of wildlife law or rule, all Class A misdemeanors on January 1st, 2022. On January 31st of 2022, he was terminated from the Independence Police Department. On February 15th of 2022, Mr. Medeiros entered a plea of not guilty to all charges. On January 9th of 2023, after completing 20 hours of community service as part of a plea agreement, Mr. Medeiros entered an amended plea of no contest to count 2 and was convicted. Counts 1 and 3 were dismissed. Mr. Medeiros' fishing license was suspended for 3 years for angling only. The department's review determined that Mr. Medeiros did violate the board's moral fitness standards as follows. Dishonesty. Mr. Medeiros admitted he was intentionally dishonest on multiple occasions during the Oregon State Police investigation into his criminal angling citation. Misconduct. Mr. Medeiros engaged in misconduct by violating criminal law and harmed the efficient operations of the Independence Police Department by violating the Criminal Justice Code of Ethics and harming the reputation of the agency by violating criminal law and lying to Oregon State Police investigators. Chair Nell.
Thank you. We're looking for a consensus to adopt the record or return it to staff. Thumbs up would be adopt, thumbs down, return it to staff, and we'll talk about it. Appears we have a consensus. Anybody disagree with that consensus to adopt the record? Seeing no one, we'll open up and discuss aggravating and mitigating factors.
Mark Daniel for the record. I think it's aggravating that when he was encountered by Oregon State Police, that he concocted a whole story about the fact that the app didn't work. He didn't have cell service, or in fact, it was the fact that at some point, he said that it was because he couldn't make the transaction because it didn't allow him to go through because he had to check the I'm actually a human deal. But he concocted a whole story here and said that he had already previously done it and didn't have cell service. And it's also aggravating that when he and the trooper met in Philomath, that the trooper was able to log onto the system and actually see that he actually did it while he was driving, and once again lied to Oregon State Police initially about the fact that he did it while he was driving down the road. So I think those are extremely aggravating.
Thank you.
Kevin Dresser for the record. Also the fact that the trooper made it very clear at one point in time, are you really going to go this direction? I mean, he had another opportunity at that point to have a moment of pause and stop what he was doing, and he continued to deny what he had done, which I believe him. It's possible the transaction didn't go through the night before, but he knew that. He lied about being on the river. He knew what the trooper meant when he first there. If he knew the area that he was in, he has fished there before. It was just the first time that year. So there was just a pattern over a protracted period of time where he continued to lie and was given opportunities to turn the course and go back and didn't.
Yeah. Thank you. Scotty Downing for the record. It's also aggravating that the whole reason for the first conduct, he was standing right next to the sign that said no fishing that close to the fish ladder, and he was doing it, and he knew he was doing it. And so the whole reason for the first conduct was another violation that he was guilty of. And then also not only lying about not having the fishing license, but lying about not being on that river before, which would potentially be an excuse of why he would be fishing that close to the fish ladder. But, it was apparent he knew what he was doing because he had been there before. And then just kept doubling down on the lie. It's very aggravating. And then trying to actively modify the situation to make his lie true.
Shannon Anderson. I also noticed, I'm trying to decide, is it a lie? Fabricating evidence, but actually went to the lengths to present something that had been created at that moment to display it as evidence that they had made a purchase earlier. That to me was aggravating.
Yeah, it's got down to where he lied about his bank account. I mean, he was lying on top of lying on top of lying about, again, back to what we discussed before. It was January. If you don't have a fishing license in January, you say, hey, I just haven't renewed my fishing license, you're gonna get a citation and move on. So the trooper had already said, I'm just gonna give you a warning for the fishing too close to the fish ladder. So he had ample opportunities to just do the right thing, even though he made him, he was wrong in not having a fishing license. So I'm Scotty Downing. For the record, I have no mitigating information on this case.
Because in light of thinking of something mitigating, I would say that although he identified himself as a police officer, he did not try to use that in any way to, or it did not appear that he did, to influence.
Thank you.
Rob Wood, for the record, I would think that's an aggravating thing, to actually point that out. Say, hey, I'm not using it, but I just want to let you know, because you're going to probably find out. That's putting it out there.
And Shannon Anderson, one of the reasons I would rather know has to do with my safety. And although somebody could lie, there are things that I can do to quickly check to see if that is true or not. So I personally, as an officer coming upon somebody, I would rather have that conversation.
Yeah. And I would say that the topic of him being armed or not, and if he was armed, then certainly he would say, I'm armed and I do have a permit to become a police officer, but that never seemed to come up. So his reason for maybe identifying himself for a police officer never really surfaced, other than, I don't know how you would find out if you just checked your fishing license, but. Anything else? All right, Jennifer, do you want to do the overview? Thank you.
Aggravating, when he was encountered by the Oregon State Police, he made up a story about the app not working and then and said the transaction didn't go through the night before. When the trooper and he met up later, the trooper saw that Mr. Medeiros actually made the transaction on the app while he was driving to the site where they were going to meet, which was essentially lying to him. The trooper gave him an opportunity to, change his story or his statement about what had happened, but he continued to lie, and that pattern of lying just kind of, was part of this whole time that he was with the trooper in many different instances. His whole reason for, saying that he was next to the sign while he was out fishing was really a lie, because later on it was determined that he had been fishing there before, so he knew that standing next to the sign was going to be a violation the way he was fishing there. He continued to modify the situation as this conversation went on with the trooper, which kind of perpetuated his lie. He went to great lengths to present something that this is how I heard it. He went to great lengths to present this information about having made this transaction on this app as if it had happened earlier when it actually had happened just now. He had plenty of opportunity to do the right thing. And then there was kind of a back and forth about aggravating and mitigating in terms of pointing out he was a police officer. On the mitigating side is he didn't use that status to influence the situation. On the aggravating side is that maybe he did, because he didn't say anything about whether he was armed or not during that conversation.
Okay.
And Shannon Anderson for the record. If we discourage folks from identifying themselves to us as police, some misconduct might not come forward. It is the way that we might know if they're not identifying it. So I just hesitate to have folks think that they're going to get in trouble for misuse of authority simply because they identify themselves as a police officer. Because it is our way of knowing. And if I stop Kathy for something that doesn't fully amount to a criminal, that I'm not issuing a criminal citation or asking the DA to charge, then I can at least call somebody and say, hey, just for your awareness, this is going on. But if I never have that information and I never know that nexus, that opportunity isn't there. And I would hate to dissuade officers so they're afraid to identify who they are. So.
Scotty Knight for the record, this person knew he knew he was lying, and he knew he was going to get found out. And he said afterwards, "Oh, I'm also a police officer." So of the two people who knew if he had a license or not, he knew he didn't have a license. He knew he was in the wrong, and so I think in this situation, since he knew he was wrong and this investigation was happening, him bringing it up to me when just watching it, I'm like, he's trying one last ditch effort to say maybe we can stop this whole thing. Because the trooper was very professional, but was also doing what he's supposed to be doing, and he's trying to find out if this person has a license or not. So.
I guess, does that mean that, are we asking to add misuse of authority? Because this record says that they could not find.
I don't think it goes to that level, but it was just in talking and aggravating and mitigating. I think maybe it's going to be what it's going to be. It's probably going to fall somewhere in the middle.
May I just clarify that?
You may.
What I'm hearing? So what I'm hearing, in addition to it could be aggravating, is that potentially it is because he made this statement, I'm a police officer, after he had been through this lying game with the trooper. So it kind of adds to the fact that perhaps his presenting himself as a police officer could have been used as an influence.
Correct. And the trooper was careful to say, I had already let you know if your license is good and everything, I'm just going to give you a warning for this fishing or angling in too close to the fish ladder. So the trooper was letting him know, I already told you, I'm only giving you a warning. It has nothing to do with you being a police officer, which I thought was very appropriate. But so I mean.
And then on the mitigating, it's kind of this overall sense that if we don't allow police officers to identify themselves, we may miss opportunities to find out about misconduct.
Yeah, I just want to make sure that we're not making it aggravating every time somebody identifies themselves.
So Rob Wood for the record. Chief Anderson, I agree with you whether it was appropriate or not, but I don't think it's mitigating against what he did. That's why I gave the other point of view that it actually, I think he was using it to try one last ditch effort, as Chairman Nouwen brought up.
Yeah. I'm trying to remember when it was brought up, but I thought they were still at the bank of the river, but I could be wrong.
They were. He'd asked him for his license, and he gave him that, and he said he didn't know about he explained where he thought if he cast out into that area and didn't start fishing till his line came back, and he says, well, I'll just give you a warning for that as long as your license is good and everything. So he had said that already, and then he said, oh, by the way, when you go check, you're probably going to find out a police officer. So I think the trooper had already made the decision, going to give you a warning if everything's on the up and up. So
Alex Gardner for the record. I see the chief's point and just note that sometimes information can be both aggravating and mitigating depending on a little bit on the context. So this is one of those cases, the violations were not the most egregious poaching type violations, but that cuts, so that might cut in his favor if he'd owned it, but it cuts hard against him because it doesn't take much to get him to lie. So so you could, for my 2 cents, you could put it in the mitigating and aggravating categories both. It's not going to shift the balance of it.
Right. Are we good with the aggravating and mitigating? We're good, we have good consensus on that? Okay, now we need to discuss if there are moral fitness violations, we can affirm, modify, or negate. Need a motion? Discussion?
Move to affirm Alex Gardner for the record.
Scotty Downing for the record, I'll second.
All right, we are voting on a motion to affirm the moral fitness violations. Chair Nowling?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lawford?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, now we need to decide if we're going to take action or not. Need a motion? If we vote to take no action, please include why you're making a motion to take no action.
Shannon Anderson, I make a motion that we take action.
Mark Daniel for the record. Second.
All right, we are voting on a motion to take action. Chair Nowling?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
So we need a discussion, a motion regarding the amount of ineligibility. We are looking at 3 years to lifetime for dishonesty and misconduct. Open it for discussion. Anyone online? Let's start.
Mark Daniel for the record.
Kevin Dresser.
Go ahead, Kevin.
Nope, go ahead, sir.
Okay, well, based on the amount of lying and such, I'd certainly like to start the conversation by suggesting 10 years of ineligibility.
Cotting for the record agrees with that.
Barrett for the record, I would have to agree. We had a case earlier today that we went a little bit lighter, but I think that due to some of the very intentional acts to try to, I think the word fabricated evidence, to try to prove his point and to continue on with his make-believe story is more egregious than the one earlier, therefore resulting in, I think, more time appropriate.
Shannon Anderson, I agree with that.
All right, someone will make a motion for 10 years?
Mark Daniel for the record. I make a motion that he receive 10 years of ineligibility.
Cotting will second.
Barrett.
So Connie got it.
All right, we are voting on a motion for a 10-year ineligibility period. Chair Nowling?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lawford?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, before we go to the next case, we kind of have to have another consensus. Do we want to just eat lunch as we go? Do we want to take a break for lunch? What would we like to do? do one more case and then decide?
I'm always in favor of food.
I could second that.
Can you eat lunch as we go, or do you want to?
Good by me.
Yeah.
Okay.
Consensus.
Yeah.
We have a lot of cases today, so I think the more we just keep moving, I know it's tough, but
Right.
I think
I agree. I think we have 4 left.
we have 4 left. We're over halfway though, so it's good.
I'm just gonna take 5. I get food.
Yeah, maybe take 5, grab some food, and then we'll move on to the next case. Yes. Unless
Yeah, if
Kathy's
you
telling
want
me something else.
no, Chair, if, this would be a great time while you're getting, food and settle back in, if the director can give his report out, should take less than 5 minutes, and then he's got other commitments.
Yeah, if we, in fact, if we want to do these, do we have other, it's just your update? Or is there other, because I was saying,
The division ones we can do at the end, and we're fine. And if it
okay,
gets
but I was saying while
long,
we're
we
eating,
can-
if you want to do division ones.
Yeah, so,
But,
yeah, so please, help yourselves and
so why don't we take 5, grab some food, and then people can give you attention, and then, okay, cool.
thank you.
Chair, thank you. Phil Castle for the record. For those of you who don't know me, I'm Phil Castle. I'm the Director of DPSST. Thank you for the opportunity to address you here today. And thank you all for being here. And first and foremost, I want to echo Member Gardner in saying thank you for the staff. There's a lot of work that goes into these policy committees and the boards and so forth, and DPSST has a lot of these to run, and the team does a lot of work, and they have done so much to standardize these processes, and it's getting better and better all the time. So thank you so much to them. And also thank you to you. You have a metric ton of paper next to you in which you have to read to prepare for these, and you all have done that. And that's a lot of time, and you all have a lot of work to do in your regular jobs and what you do in your everyday life, and yet you're taking the time out to do this very important work. And I don't take that for granted, and none of us do here, so thank you very much. Along those lines, you know, what you're doing is so critically important. I want you to know that in the continuum of public safety, we start this process at the very beginning. The values that you're reinforcing at this table start at the very beginning down those halls, right? And they really do. This place is where the science joins the culture. And we take this very, very important here. And something that I do here is I talk to every single student, I talk to every single class, and we really emphasize these values. And as you sit here and you talk about and you reinforce and you enforce that we're living those out, I talk about those, and I talk about with the students where they fail sometimes. And we talk about what happens in this room and so forth. And so they know about it right from day one. So I just thought I'd share that with you, and how important that is. Right now, as far as DPSST, we're sort of recoiling right now after our fall and winter of 60-person courses and massive surge in the amount of students that we were training, and there's sort of a wake was left in that, and we're trying to recover and get back to a place where we're really focusing on quality now, and we're preparing ourselves to go again into a large surge, and to be prepared to do that even better. We don't anticipate our volumes are going to go down. They're going to stay the same, but we're going to handle those volumes in a better way. We're going to spread that volume out a little bit more, and we have our facilities, we're going to use them a little bit more wisely so that we are able to give our students a better experience throughout, and we're able to stay within statute the whole time. Our projections have been excellent. Our data team has done a phenomenal job in projecting where our volumes are going to be, what they're going to be at. We've been within 10 to 20 for the last 2 years. That's phenomenal. That's through good surveys, through the study of the market, through national research, and it's been super, super accurate. So we're really starting to trust our data team in that, and we are projecting the same volumes we've had the last 2 years. We're projecting those same numbers for the next 2 years. And what we're doing about it is we're preparing a schedule over the next biennium that we've never done before. We've built a schedule. We are building a schedule to the volumes instead of what we're funded for. What we've always done over the past however many years is we've scheduled what we were funded for. Well, that has put us in a tailspin when we have more than that, and we're then cramming people into the academy, which creates chaos, not having enough instructors, compromising quality, potentially compromising safety. We're not doing that. We're scheduling right up front, making sure that we have enough slots based on our projections, regardless of whether we have the funding for them or not. The good news is we have way more funding at CSL than we did 2 years ago. So we're within we're within shot of that by about 60 students or so. So that's really, really good in terms of basic police. We need to train about, I think 80 more in corrections. We need to train quite a bit more PNP in the next biennium than we did this last biennium because of 4002 for sure, but we're planning for all that. That's our long-term planning is accommodating for all that. So we're really encouraged for how we're thinking about things going forward, and you can expect to have a lot more visibility into that as a customer, right? You'll be able to see our schedule, you'll be able to plan better and know where you want to send your students as you do your hiring planning going forward. I think our constituents will appreciate it. Like Superintendent Cotting, all state agencies right now are preparing for our budget, putting our budgets together, waiting for the governor's recommended budget based on our agency recommended budgets. There's a lot of work going on right now about that. I'm gonna turn this over here just a second back to you, Chair. But before I do that, I do want to celebrate a member of this Police Policy Committee that is going to be falling off the Policy Committee, who's been an incredible member of this. Very, very intelligent, lots of contributions since I've been here, and never afraid to add in and be a standout with great contributions, which I think is really important. And even to go against the grain, right? When you're going against the grain, it's really, really important that we have that. Not a member of the bandwagon for sure. Major Gardner, thank you so much for what you're doing. I have a little something for you here to celebrate your time with the Policy Committee. And there's a little letter here thanking you for your service. So thank you so much. Appreciate that.
It's a pleasure.
Yes. And congratulations to you for that service. And I know you're going to continue on with us for
Couple months, not
yeah.
Yeah.
Yeah. But thanks for your continued service and your contributions. It's a pleasure. Yeah. Thank you. Give me a hand.
And Director, if I just may add a personal note, while I was on the Police Policy Committee and the ARC with Alex, again, as a peer, phenomenal insight, and just obviously your ability to articulate the thoughts on both sides of the fence is invaluable. And I think that you have set a tone and demonstrated to your peers on what it means to be engaged in these committees. So I personally thank you as well.
Thank you. Before I turn it back over to you, Mr. Chair, I want to, in keeping with sort of a new tradition we've started, I want to make sure I leave time for questions. If anybody would like to ask me questions about anything going on here at DPSST, anything the Policy Committee would like to know, members of the public, by all means, happy to answer any questions.
I have a question, just to clarify. I am from Tigard, and we are always talking about the officers waiting to get into academy. Is this the academy you're talking about?
Yes, ma'am.
Okay, thank you. Thank you.
And that there is no backlog.
Right.
Yes.
That's amazing.
So Director, last time you talked about the plans of the facilities and boosting up regionals and I don't understand the legislative process and budgeting. When would we find that out? That your budget would be approved to do those things?
This is a long process, Member Wood. Phil Castle for the record. So our agencies right now are approved to talk about what's called our policy option packages, which are the what you're talking about and what I've briefed already, we have 3 policy option packages that we've put forward. One of those is for our learning management system. The second one is for a the words are escaping me, a facilities package. Third one includes personnel that are specifically for regional, some administrative personnel, but mostly for regional support around the state. Those will be considered, this is a three-part process. First is your agency requested budget. So we put together our requested budget. Then the governor puts together her budget. So she'll consider what agencies are asking for, and then she will put together her budget that may or may not include those things, right? And that goes forward, and then the legislature will consider all of those things, and then it will be go towards what's considered an LAB, legislatively approved budget, and that happens during session. So we're quite a ways, long ways away from knowing whether or not those things would be approved or not. So
I see.
We're at the early stages of this, right?
So in a perfect scenario, when would that date be if everything just worked out just right for your budget, proposed budget?
The end of June.
What's that?
The end of June.
The end of June?
Yeah.
Okay.
Yeah.
All right.
Thanks for the help on that, Vice Chair.
Yeah.
Yeah.
Another important date is December 1st, which is the governor's recommended budget. So that'll be something to closely watch and see what's in there. And then once that comes out, the director will be able to speak to that directly, which will be hopefully very good.
Thank you.
Any other questions? All right.
Thank you,
very
Director.
much, Mr. Chair.
Thank you. All right, with that, let's get rolling. Brian Needham.
Same book, should be a continuation, so volume 2.
Jennifer, whenever you're ready to present the case.
I want to make sure we're on the same ones that need them. Correct, okay.
Yes, if I'm, either way.
Yes,
Okay,
that is
yes.
correct.
Thank you. Jennifer Lavario for the record. The case before you, it's been before committee before. It is back before you because the committee in August of 2023 asked for additional information. So this has been updated with some additional information. Some of you may have been on that committee. Many of you probably were not on that committee. But I'll just go through it like I normally do. The department opened a professional standards review after Brian Needham resigned from the Harney County Sheriff's Office on July 7th of 2020. His resignation came after a Brady investigation determined he would never be subpoenaed to testify as a law enforcement witness again by the Harney County District Attorney or DA-elect. The Harney County DA found inconsistencies between evidence and testimony, violations of individuals' rights, and inaccuracies in written reports by him. The Harney County DA investigation was provided to the Harney County Sheriff, who recommended that Mr. Needham's employment be terminated. As I said, this case was presented to the Police Policy Committee on August 17th, 2023. The department was able, the information that was asked of the committee, asked of the department to obtain, we were able to obtain much of it, but not all of it. And I believe in my report, there are some exhibits that lay out what we asked for and what we received. The department's review determined that Brian Needham did violate the board's moral fitness standards as follows. Dishonesty, Mr. Needham intentionally misrepresented the truth in his reporting of events that occurred during arrests and was untruthful in his testimony in court in several cases reviewed by the Harney County District Attorney as part of a Brady investigation. Misuse of authority. Mr. Needham used coercive tactics with the intent to convince a suspect to consent to a search by utilizing his authority to leverage several other law enforcement officers to pressure the suspect into consenting and to obtain an advantage through this coercion for himself and his investigation. Misconduct. Mr. Needham undermined the integrity of his position and the law enforcement profession by exhibiting dishonest and coercive conduct during investigations. This conduct compromised his ability to be subpoenaed or testify as a law enforcement witness, thus compromising his certification standards and harming the efficient operations of the Harney County Sheriff's Office and the Harney County Circuit Courts. Mr. Needham's conduct threatened to harm 2 individuals by causing loss or damage to their constitutional rights. Chair Hanning.
Thank you. We need to have a consensus to adopt a record. Looks like we do, and just on a side note, I do appreciate all the extra work. I know that this was a lot of extra work, and I do appreciate it. I was on the committee at the time. Appears we have consensus. Does anyone feel differently? We need more information? Thank you. Here, we're on the back here.
Aggravating and mitigating.
Aggravating and mitigating, yes, we're on page. We'll now discuss aggravating and mitigating.
Rob Wood for the record. I think some mitigating items would be that watching the body cam and listening, it was extremely windy and overpowering what I could hear. And so I can't sustain some of the things that the investigation revealed about getting permission on a couple of them. And I think another one was whether they asked 2 or 3 times or something like that, whether that was material or not. But that's what I had a problem with, and I think that somewhat mitigating on the allegations.
Scotty Downing for the record. I agree with you. Some of the stuff was happening off camera, the wind was blowing. Other times there were multiple officers involved and you couldn't really tell who was getting what information because it was sometimes only one body camera with 3 or 4 officers. And so it was really hard for me to discern whose information are we relying on here, whose information is this officer relying on to put in into some of these reports or affidavits. I mean, it was really hard for me to make a determination that this is absolutely false or this is absolutely true because, like I said, it wasn't necessarily clear, and I don't know that there's any more information out there that could help us make it more clear. But and I guess mitigating the tone of these, the tone of his conversations just seemed very investigative in nature. And a lot of it is up to interpretation. I think at one point, one of the gals says, "No, Bob." I mean, these are small town things, and they're calling each other by their first names, like these folks all know each other. And I'm like, is it no, you can't search, or no, don't arrest me, or no, don't find my drugs? And I think that was very subjective, and so unfortunately, I'm still kind of where we were before, even with some of the video stuff. So I don't know if that's, I guess it's mitigating in the fact that it doesn't add a lot to the allegation. The video doesn't. But I would love to hear everyone else's thoughts.
Yeah, Shannon Anderson, I would agree that it was complicated, it's complex. I think had this been something where the DA's office had maybe reported it as it was occurring and there had been attempts at mitigation, we would have had a more clear line and maybe more clear information, but it was difficult at best to put all the pieces together and listening to the audio and the videos as well. I was trying to decide what part is lying and where do we have performance because it's something that's subjective. It was difficult.
Yeah, Scott Downford. I saw a lot of things in there that I think maybe you would attribute more to small town policing. I think they had her brother, the suspect's brother. All of a sudden he was saying, "I love you," and I'm like, "Whoa, is this?" But he's in uniform, a corrections uniform, and but everyone knows each other in these small areas, and so it's just, to me, I'm like, this is terrible tactics and things that are probably not best practices. But is it intentionally misleading or wrong? I had a hard time answering that.
Well, Shannon, for the record, some of the things that, I mean, they're low-hanging fruit where I was like, okay, well, yeah, no, this is a misstatement. Or things like the purse being on the trunk, in the trunk, around the car. And those are, you know, you can mitigate that by watching the video before you write your statements. And, you know, we encourage folks to do that. And it's time consuming, but it does help with this type of investigation and this type of issue.
But it seems the subject here didn't have the camera. It was always someone else's camera usually that was capturing the main part of the event, and our person is off, so you don't know what kind of body language and things you're getting. So,
Alex Gardner, for the record. When there's an allegation of lying, I always try to think of what the potential benefit is of the lie, because the alternative is the person's mistaken, or the person was confused, or and you know, the purse example is a good one. Whether it's on the trunk or in the trunk, you know, where it just has no bearing on anything in the case. So I'm more inclined to think that that's an error in memory than a lie. And you know, some of these things, whether he said I told the individual at least 5 times that she needed to unlock the door. Well, it's only twice, really. Maybe it's twice, or maybe it wasn't picked up on the audio. But so, you know, at worst, it's an embellishment. Can I imagine the, you know, construct where that's a useful lie? No. So there's just a lot of fuzziness here that's uncomfortable. And it's messy police work for sure.
Scotty, I think the problem was we had this allegation, and then they went back. And to your point, they went back and started reviewing everything they had. And it's really difficult for an agency to do a good investigation when it's not happening at least some time near when the incident happened. They went back and they're like, oh, this incident happened, that incident happened. And so people's memories aren't going to be as clear. And obviously in some of the records they just don't have. So clearly we weren't able to get everything. So I'm with you. I have a hard time seeing the benefit of these, I guess, dishonesty. I know we were totally unclear if that was mitigating. I'm sorry. We went on into a whole discussion here. This we're not following this anymore.
Get back on it.
Okay, we'll get back on track. Okay. So I think so far things have been mitigating as far as it's mitigated our ability to agree that there's dishonesty intentionally. Is that?
Yeah, and Chair, we have not heard anything on misuse of authority or misconduct, any concerns there, which could impact your decision whether to affirm, modify, or negate later on. So there's some discussion on the other two. I would appreciate it.
Alex Gardner, for the record. I assume the allegation of misuse of authority is based on the idea that she was coerced. And again, you know, clumsy police work doesn't automatically mean coercion. And when all the people know each other, that fuzzies it up too. I'm struggling with it.
And Scotty Downey, for the record, these are mainly were around narcotics investigations, mainly. And narcotics investigations are unique in the fact that a person committed the crime can cooperate, can be told to cooperate, or be offered to cooperate, which could mitigate their amount of exposure they have. And so narcotics officers, it's a very common practice, and it's useful oftentimes to the suspect. If they cooperate, they can reduce their liability, especially if they're not the ultimate target of the investigation. So it seemed to me that there's more of that going on. There's an attempt to kind of figure out where the drugs came from, or you can cooperate and potentially get out of some of the trouble. And so I think that's a fairly well-established procedure in narcotics investigations. And then I would Scott Hand for the record, I think if we go back to now the misconduct, it's all kind of tied to the same things. So they're all intertwined. So Jennifer, if you want to try, maybe when we hear it back, it would make more sense to us.
Yeah. Well, there's a theme, of course, that the body cam footage is very difficult to hear. So it's hard to know whether certain things are said or not said or under what circumstances. In other words, asking 2 or 3 times under what circumstances, what's the context, so it's hard to hear what the context is in some situations. There were multiple officers there, doing multiple things, who was getting what information, that was not necessarily clear. The tone of Mr. Needham's conversation seemed investigative in nature. That I took as mitigating. What did no mean in the context of the conversation that was being had? Was it no to consent or was it no to something else? The complexity of the situation and having to investigate it later made it difficult to understand what actually occurred. Had this been investigated as these events had occurred, we may be in a different place right now. There's some question marks in the committee members' minds about what is performance and what is lying, based on some of the things I just mentioned. Maybe it's small-time policing, which has a different culture and a different way of doing certain things. Maybe it's an error in memory and not lying. At worst, maybe it's embellishment, or clumsy police work. Doesn't necessarily mean that there's coercion. When you know everybody in a small town, things can be interpreted differently, or the way things are done may be different, but not necessarily coercive. And then narcotics work is sort of a different animal, and there are things done in narcotics work to gain cooperation for an investigation that are different than other types of police work. Things like whether the police was on, or the purse was on, in, or around the vehicle can be mitigated by watching the camera footage before that happened. So, I heard from you that this was basically all mitigating and also partly your deliberation about the moral fitness violation. So it kind of was serving 2 purposes.
I would agree with that.
Can I ask a question? When I read the report from the DA's office when they were reviewing anything, did I miss it where, so they say that the audio of the camera doesn't match the reports, but they never said that I can find, and I might have missed it, 2 officers had conflicting testimony, or another officer documented this. There's no, it's literally the comparison of only his stuff. Did anybody ever come out and be witnesses or testify to what was happening in these investigations? Did I miss that?
Jennifer Lavario, for the record, what I can tell you is that getting the full record of what occurred here took 2 times, and even then, what you have in front of you is what I've been told is the full record based on what the DA has told me and what the Harney County Sheriff has told me. And there is nothing else to provide us.
That's so interesting.
Alex Gardner for the record. It's in aggregate, if you take all the sort of shading pieces, it smells bad, right? It does, it looks bad. But if you sort of, for me, if I sort of examine every pillar they don't stand independently, every little piece. It's just too wobbly. So for me, it would be hard to kill a career based on this. It's too wobbly.
Well, when we're talking about dishonesty, I think we need to be extremely sure of ourselves. Like you said, it's a career killer, and when you see it, you know it. I think we've seen it today, and I just keep struggling with this, because there's still so many parts I don't know. Obviously, in these cases, there will always be things we don't know, but to make the assumption that this person is intentionally being untruthful or lying without having more information, I'm going to have a hard time with that. So I think you've reviewed it. We've kind of discussed the moral fitness violation. So now we need to either affirm, modify, or negate these moral fitness violations.
Rob Wood for the record, I'll make a motion that we negate all three moral fitness violations because we just don't have enough information or to sustain any of them. There's enough questions, let me say that. There's enough ambiguity to not be able to sustain any of them.
Looking for a second? Or a different motion?
Kevin Dresser, I second it. I mean, we've looked at this case twice. We sent it back. This board, this committee has made every effort to get the clearest picture possible and the most information, yet we're all seemingly agreeing that there's just these areas that are incomplete or gray areas that we just can't make a determination based on the information we have.
Thank you.
All right, we have a motion. We are voting on a motion to negate the moral fitness violations. Chair Downing?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Martin?
Aye.
Committee Member Lockwood? Aye. Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you. That's it.
Quinn Sanson, yep.
Okay, so moving on to Quinn Sanson. Same vote, right?
Yes.
Whenever you're ready, Jennifer. I know we're hurrying, so let's take your time.
Department opened a professional standards review after Mr. Sampson resigned from the Corvallis Police Department during his probationary period. His resignation came 2 days prior to the Corvallis Police Department recommending termination after an internal investigation indicated potential misconduct. The investigation found a continual pattern of poor performance after Mr. Sampson received copious amounts of training that exposed the Corvallis Police Department to liability and negatively impacted the public's perception of the organization's ability to effectively investigate criminal activity. The department's review determined Mr. Sampson did violate the board's moral fitness standards as follows. Misconduct, Mr. Sampson's arrest of an individual without probable cause and poor investigative work harmed the arrestee by violating his rights and threatened the efficient operations of the Corvallis Police Department by exposing it to liability and potentially disabling the district attorney's ability to bring Measure 11 charges in the case. Chair Young.
Thank you. We need a consensus to adopt the record or return to staff if needed. Looks like we have a consensus to adopt the record. Does anyone disagree with that? You're not. Okay, we'll have a discussion of aggravating and mitigating factors.
Before that, Shannon mentioned, I cannot hear or play two of the videos. It kept saying they're too small for my player. And even to download them, it said the file size was too small to play. And it was the two, I believe, that had the audio. I could see the other ones, and I could see the interview when he went back to the house. So I just want to disclose
Okay.
that I was not able to see that.
Kathy McAlpin, for the record, anybody else have any difficulty with this particular case with the videos? Okay, at least one other note.
But you did end up with them, correct? Or, Scott, down for the record, I'm asking Rob.
That was another case.
Okay.
The difficulty that I ended up with them. This one, it sounds like I
You're the same,
didn't
okay.
see or hear. And again, I didn't know what I didn't know until it was just brought up.
Member Lofton.
Even more so, Patty Lofton here, I did not know there was video until you sent the email yesterday. I was not aware that there were videos to go with these cases. So I'm not able to chime in based on video footage. So I will know for next time.
Okay, so we have potentially 3 that would have to abstain, don't have.
We have Terry Rowan's raising.
Oh, okay, thank you.
And then Megan also.
Go ahead, Terry first.
Yeah, I couldn't get them to play either.
And I guess I would ask that as long as our decisions aren't based off of, like, as long as I'm not going, I agree, I could hear the car revving its in, like, so I think there was a time in our history when we didn't have some of these items, and the way I read the reports is how I knew that there were audio, because they're quite descriptive in the reports. I thought that they did a good job of being descriptive. So I just wanted to make sure you knew I could not hear the words that were being said in just the short clips. The long ones I could.
Megan, was that your same experience? You had your hand up?
Yes, same as Chief Anderson.
And then Terry, Rowan has something.
Terry, did you have something else?
No, I just don't know how to unraise my hand.
I'm giving you a high five. So I guess our options are we could pull this from the agenda, check the audio, and that's my recommendation, because I don't want to move forward and make a determination when we don't have all the information that is clearly available to us. And so what do we do, make a motion on that? We make a motion, we cannot adopt the record.
That is correct, to see if we could try and clean up or fix the technological issues with the.
Okay, and then if we can't, then we will go with who we have meeting next time.
Right.
Shannon Anderson again. I guess I'm asking, is it relevant enough, because it does not seem that this was intentional lying, that it was a performance issue. And so that makes me wonder if we would even get to this vote. So,
Rob Wood, for the record, I'm totally on the same page as Chief Anderson, that even without what I don't know, what I didn't see, I think I have a conclusion or a belief already on this.
Mark Daniel, for the record, I agree that I have come to that conclusion already, and I'm satisfied with my beliefs.
And is this, we're on the same page that this seems to be more of a performance issue than a moral fitness violation, which the board would not take action on, I guess. So I'm not trying to get too far ahead of myself.
No, I am tracking completely.
Okay, and then on mine, I don't know if you guys can hear what we're saying. Are you tracking what we're saying in the room? Okay. So you tell me the procedure for getting there. Someone tell me the procedure for
should
getting
we
there.
have a motion to remove the misconduct?
I'm gonna have Jennifer Howell step up here, guide you all.
Rules expert.
Well, and it's not, sorry, Jennifer Howell for the record, it's not actually in the rules, it's the process of the committee, but I think perhaps for a clean, clear record on what you're basing your decisions on, let's modify the staff report to exclude those particular videos from your discussion.
That's a good idea.
So that you can identify that from the exhibits listed, you're doing the staff report, the attachments, but exclude those particular videos from your, if you found that the written reports of those videos was sufficient to review.
Alex Gardner for the record, I think that's a great idea, and to further firm the record, it might be a good idea to ask if anybody who did see the video found anything inconsistent with the reports that they'd like to raise. Because if there's silence on that, then we know the written record is adequate.
I don't know if Megan just hasn't lowered hers.
Was her hand still?
Well, or is it valid? No.
No, it's her.
Okay.
I've got this under control.
Yeah.
Just kidding.
It just looks like it's.
Okay, so we're going to, someone is making a motion to modify the record. Who's that?
Conning will make a motion to modify the record to the written material and video that was available and exclude the short snippets that were unavailable.
Second. Scotty Downing for the record, I'll second that.
Thank you.
Thank you very much.
All right, we are voting on a motion to modify the record as discussed. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, so now we go to aggravating and mitigating. So now we'll open up for aggravating and mitigating.
Member Townsend, mitigating. I was noting in the Sansom's letter that he had performance evaluations where it was marked meets expectations. So if that's correct, I didn't see that here in the file, but I just wanted to add that, and that he did admit responsibility for several of the things that he performed poorly on.
Alex Gardner for the record. Also, as soon as he realized that he made a mistake, he owned it and he reported it to his sergeant.
Yeah, Scotty Downing for the record. The main issue appeared to be a mistaken identity, an error, and maybe could have done a better job, but he's a newer police officer, and like you said, he admitted it. They did rectify the situation. It is unfortunate when that happens, but that does sometimes happen in police work. You make the best decision you can with the information you have, and so I found that mitigating. This seems to be a performance issue to me. Anyone else? Terry Rowan, your hand is still up. You want to jump in? I call on you every time.
No, again, I don't know how to unraise it, so.
We want more people to communicate, so.
Terry, if you try to raise it again, it'll go away.
Okay.
Okay, you can go ahead.
Okay. Jennifer Lavario for the record. We have only mitigating this time. The consensus is that it's a performance issue, that his performance evaluations according to his written mitigation all said that he met the expectations of the job prior to this event, that he owned his mistakes as soon as he realized them, that he was a newer officer, and once the mistake was observed, it was rectified.
Okay. Do we have a consensus on that overview? Looks like we do. Okay, let's discuss the moral fitness violation categories. We can affirm, modify, or negate. And in this case, it is only misconduct. We need a motion.
Connie will make a motion to negate the allegation of misconduct.
Shannon Anderson, I second that.
Thank you.
We are voting on a motion to negate the moral fitness violations. Chair Nowdy?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, Sermi,
Cerny.
Volume 3, first one.
Mario, for the record, before I go over the summary, a correction was made in-house that was not part of your packet, and that is on page 2. Pardon me, page 2.
It's page 1.
Page 1.
Page 1,
Last paragraph.
thank you. Last paragraph, under material events and conduct, after several witnesses, including Surmey should be removed. That is an error. The record we have reflects the change. The record you have does not reflect the change.
Needs to be crossed out.
Does that make sense? No?
It's very last one. Here, they didn't.
Got it. Mr. Sermi was not interviewed.
That makes sense.
And which aligns with his mitigation statement stating such.
Whenever you're ready, Jennifer.
The department opened a professional standards review after Daniel Sermi resigned from the Oregon State Police while under investigation into allegations of dishonesty and performance stemming from a personnel complaint filed on July 7th of 2020. The investigation into the complaint was provided to the Josephine County District Attorney's Office, which determined Sermi would require a Brady designation. The department's review determined that Mr. Sermi did violate the board's moral fitness standards as follows. Dishonesty, Mr. Sermi intentionally misrepresented the truth in his report writing and interactions with dispatch, responding officers, and the subject during vehicle stops. Misuse of authority, Mr. Sermi intentionally used his position as a public safety professional to obtain the benefit of searching and seizing persons and property without following procedure and manipulated the facts to support his decisions in his reports. Misconduct, Mr. Sermi harmed the efficient operations of the Oregon State Police by misrepresenting or omitting facts in his reports such that the Josephine County District Attorney placed him on the Brady list, thus undermining his future credibility and the credibility of his current cases brought before the court. Mr. Sermi's improper procedure related to search and seizure, Miranda rights, and the manipulation of facts during his investigations harmed the civil rights of others and the integrity of his investigation. Chair Nowdy.
Okay, we need to have a consensus whether to accept the record or return it for more information. We're okay with the record? Thumbs up?
May I just make one statement about that? We're accepting the record as corrected.
As correct, right, with the crossed out.
Yeah.
Right. With including Sermi removed. So we're looking for a consensus on that. I think I got it. Thumbs up. Anyone disagree with that consensus? Okay. Let's move on to aggravating mitigating factors. We'll open it up for discussion.
Chair?
Oh, go ahead.
I was just, I was gonna ask for a reminder on the requirement, what the basis for recusal is. I know there's a standard, I can't Is independent knowledge of a case sufficient, or does a person have to make an assessment about whether that's likely to influence them?
I'd have to pull up the statement. You can identify potential conflict. Sorry, Jennifer Howell for the record. You can identify potential conflict, which is clear from being from the same agency, but if you are able to make your decision without bias, and you declare that, and the committee's fine with that, then you're able to continue to vote.
Okay, thank you.
If it's easier and clearer for you to recuse and abstain, that's absolutely fine.
Okay, thank you.
Okay, we're back to aggravating mitigating.
So Robert, for the record, to get the discussion going, and I'm not sure this goes to aggravating or whether it goes to mitigating yet. There are a lot of inconsistencies between what I watched. There's a lot of data here, a lot of information. What I watched and what was written. And it may parallel the other case we had earlier in Needham, where was it embellishments? Did it change things? The 2 feet versus 5 feet when he backed up? Did I sidestep? Which I think he did, but the investigation said he did not. Just leads to an impression that they're trying to find something and make the investigation and the finding more concrete. So I'd like to hear other people's thoughts. I'm not saying that's mitigating yet, because there probably are some aggravating things here, but that's my overall impression. A lot of inconsistencies, not only between body cam and his reports, but between the investigation and the body cams.
Anyone else? Probably gonna need some more discussion on this one. Anyone online want to weigh in? Gonna call on someone.
Probably for the record, I'll go further into detail then. For instance, one of the allegations is stopping the body cam. The audio of the video. But from seeing many other body cam videos, that's been typically done when they're away from a suspect or an interviewee, and when they're talking amongst themselves or on the phone. And that's what appeared to happen on a few of them. It appears he forgot to turn it back on. That's what I'm thinking. He forgot to turn it back on immediately when going back up to the car in one of the instances. Yeah, there's a few notes I've made just like that. The thing that he did not Mirandize the subject, but you can clearly hear him say, first off, let me advise you of your rights. Then it goes very garbled. So why would someone do that, in my opinion, if they're not going to read the rights? Maybe he did, maybe he didn't. And again, that was an audio portion of the video that I could not clearly hear him read the rights, but I clearly heard him say, first off, let me advise you of your rights. Maybe these are all mitigating things, I don't know. It's just,
Anyone else? Oh, go ahead.
Shannon Anderson. we go back to the question that you asked, which is what did he have to gain, or what was he gaining by all of this? And I guess I don't know.
Ralph Wood for the record. Sunglasses left in the back of the car. Clearly left them back there. Clearly were on her head. Clearly didn't grab them. I don't know whether he included them in the evidence report or not. But I would severely question his intent to keep someone's sunglasses. So I think it was an oversight. I think it was a mistake. I think there was also something, I'm gonna keep going here, in the reports, unless I'm confused with another case, of them never listing additional officers or other officers from other agencies on scene. Yet I think in his mitigation, he brings up, he clearly did on everything. On the tab, there's a tab supposedly for others present. He just didn't include it in his narrative. Is that a policy of OSP that he's got to do in his narrative? Okay, maybe he broke a policy or failed to follow a policy. Is that a moral fitness violation?
Captain McAlpin, for the record, Member Anderson, I don't know if your comment was rhetorical or you were actually looking to see, but in the staff report on page 5, there is at least a possible explanation when you say what the motive is, and they talked about team competition for statistics and stuff. So you can put the necessary weight on it, but that is one thing that was offered in the packet.
Scott and I, for the record, potentially could be mitigating if he's a newer troop. I think he was hired in 2020. The sergeant is doing that, having his crew go out and have some kind of competition. While it may be good fun, it's probably also gonna look like quotas or encourage enforcement for everything instead of using good sound principles. So there's not enough information about that necessarily. So there's a lot here when you break down each of them. Each of them are not. There's nothing that really says, "Oh my gosh," but there's a lot here. There's a lot of different things here. There are some things where he definitely did not do a very good job of documenting important things, or was very sloppy, or didn't do some stuff he should have done for sure. So this was a complicated one for me. There's a lot to it.
So Rob Wood, for the record, I'm going to offer what I've brought up as mitigating circumstances, including the one where on the stop, I think it was for the headlight out, he states that the driver, while in the truck, motioned to him, giving a gun symbol, like I'm going to shoot you with my hand, kind of thing. The investigation says that couldn't, there was no proof of that, but there's also no proof that that did not happen. No body cam, it was a truck cam, so we don't know if that really happened. And again, on that same stop, what did he benefit with either embellishing or just being confused on the distance of the car to when he backed up? He said 2 feet in the report, it appeared to me about 4 feet or 5 feet. Did he benefit by saying that? Same thing with stepping sideways when he backed up. The investigation says that Sermi did not step to the side, but barely changes his walking pace. But the video does show that he steps kind of at an angle. At least he traverses at an angle. while grabbing his, he put his hand on his taser, less lethal, so he was concerned for his safety. I'm gonna offer all that as mitigating.
Anything else? Anyone else? Rob, you're carrying the water on this one. Anyone online have any aggravating, mitigating thoughts? Jennifer, I think that's all we're getting.
Jennifer Lavario for the record. This one's a little more difficult to sort of discern whether we were just discussing or they were aggravating or mitigating. I heard most of it as mitigating. A theme of what did he have to gain by these allegations. In terms of the Mirandizing, in one of the situations you can hear him say, let me first say I need to advise you of your rights, but then you can't hear the actual Miranda said after that. So we don't know potentially what happened. Stopping of the audio, which is part of the report by OSP. Did he just forget to turn it back on? What I heard was it malice, or did he just forget to turn it back on? In the truck stop, he mentions that he believed the gentleman in the car pointed a finger gun at him, but there's no proof that he did or didn't do that. The distance between him and the truck, when the truck was backing up, what would have been the benefit to, again, this is mitigating what I'm hearing, what would have been the benefit to Mr. Sermi to embellish that fact? The sunglasses were clearly left in the back of the car, but was this a mistake or an oversight? Since the motive for team competition came from someone other than a committee member, I'm not including that. Because I didn't hear it from a committee member, but I did hear from a committee member that the motive could have been mitigating if, because Mr. Sermi was a new recruit or a lateral recruit, and he could have been doing it to impress the sergeant. And that's kind of what I took away from the conversation.
We have a consensus that that's a good overview of our aggravating and mitigating. So we do have a consensus. Let's open the discussion on the actual moral fitness violations, affirm, modify, or negate. And there is all three on this: dishonesty, misuse of authority, and misconduct. Not everyone at the same time, talking over each other.
Shannon Anderson. I guess I was going back through and my copy of the report actually has like handwriting as if somebody were going through and doing the investigation and picking it apart, which I found interesting. It makes some of the comments in the investigation seem even more interesting. So, like, the comments about that they didn't, I'm trying to frame this correctly. I guess I'm supporting Member Wood, in that they're making it look like a lie that he didn't introduce a passenger, but really, he says, I requested the passenger to exit the vehicle, and the comment is, I mean, it's like I would be taking a red pen to a recruit's report. It says, who's Ada? Some of these are just performance, not lies, and they're just, it seems like the way this is framed makes it look like a lie when it's a performance piece. So I'm just having a hard time putting all of this together and feeling good about it, because there may be some statements that don't line up. But it leaves me with a lot more questions. I guess about intent. Is it intentional or is it skill-based?
Scotty, now for the record, I think the pipe in the pocket or the shirt is a good example too. It's like, this is one difference of a word, but it's not going to change the, I mean, it certainly can be scrutinized that you put quotes around something and it's not what was said. You gotta be careful doing that, but at the same time, what's the difference necessarily? It's on their person. So it was almost as someone said, let me go through this report and see what any little discrepancy I could find, and then is it actually material to the case? Sometimes it was, I think, and sometimes it wasn't.
Rob Wood for the record. Chief Anderson, you're bringing up page 65 of 150 of that handwritten note. I had the same thing on mine about embellishing facts for the menacing. My understanding of menacing is not just an action, but it's the perceived action, and you can tell Sermi is concerned. Maybe he was just backing up to get closer to talk to him, but he does, in my opinion, exhibit pre-assault indicators, the way he's coming at him. So does that meet the definition of menacing or not? Was that really embellishing? I would put it out there that it wasn't embellishing.
Yeah, I agree. Shannon Anderson again. When we say they weren't going for the waistband, but they were pulling up their pants. Well, in a moment of stress, the difference between pulling up your pants and going for the waistband, like, isn't, like, I pull up my pants by the waistband. So it was really hard. There's another piece in here about saying that exiting the car, female blonde hair, and then somebody else with blonde hair over the radio, but in their report they said this. Well, that can happen as your mind actually processes. If you're broadcasting on the radio as it's happening, you may perceive, I mean, do I have blonde hair? Is it dirty blonde hair? Or is it light brown hair? And so it can just be, it can be slightly different. But to characterize these as lies is hard.
Yeah, Scotty Downey for the record. Even just with these, the notes on here, it almost appears as someone said, I'm going to go through every step of this person's day and I'm going to critique every single thing that was said and try to discount it in one way or another. And I think it would be really hard for any police officer to withstand that kind of scrutiny if every single word you have to say has to be, you say pocket instead of shirt, or you say long blonde hair instead of just blonde hair, or or 2 feet instead of 5 feet. So, now with body cameras, you can go back and double check all of that, but the officer is, in practicality, is not going to probably have time to rewatch every single moment of body camera and, critique it. So it becomes to it, is it a material fact that was mistaken? And there are some of those in here. There are some material facts that were mistaken, but there's a lot of things that are not material at all that were brought up, and so.
And Shannon Anderson, for another descriptor of it, in the report where he writes about pulling over the vehicle for the one headlight is out, and then describes it as also because it misrepresented the license plate. I wasn't entirely sure if he was trying to set the context to describe the vehicle, or if he was actually saying that he pulled it over because he has the part in there about the headlight out, and then describe it just is very unclear, and without having someone asking about that, like, what is this? It was really difficult to also say that was a lie rather than a really horrible way of writing it.
Scotty Downey, that's the one with the switch plates too that thought was stolen, correct?
Yes.
So you detain someone and you're like, so he's wrong. He's wrong. It's not a stolen car, it's switch plates, but it's still, his actions are appropriate for a stolen car, but it's not a stolen car, and it takes him 17 minutes or something to figure that out. And so, like I said, you go back over and we're just like fine-tooth combing every little maneuver, and so it's, I had such a hard time with it. I have a hard time with this. There's a lot of information, and I don't really know what it amounts to.
I guess for me, I saw really not well done police work, and I think the agency made the right decision, but calculating it out on as lies, I'm not sure I can get there.
My thoughts exactly.
Court data for the record, I agree. I don't see the clear-cut level of deception here. I don't see the intent.
I don't know what we were discussing.
Are we going to affirm modify?
Yes,
Yes,
that's what we're going to do. We're just kind of going rogue today.
Yes, you can affirm it as is, but what I'm hearing more is perhaps you're leaning towards negating these 3 allegations as presented. So that's kind of how I'm tracking it, but that's where you're at, is affirm, modify, or negate.
Rob Wood for the record, and I agree with Chief Anderson that it's performance-based. And therefore, I'm going to make the motion that we negate all 3 moral fitness standards: dishonesty, misuse of authority, and misconduct.
Shannon Anderson, I'll second it.
All right, we are voting on a motion to negate the moral fitness violations. Chair Downing?
Aye.
Vice Chair Cotton?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, one more.
Oh, Louis Topinka?
Correct.
The department opened a professional standards review after Louis Topinka was cited for driving under the influence of alcohol and failure to obey a traffic control device on February 10, 2022. Mr. Topinka entered a plea of no contest, and the failed to obey a traffic control device charge was dropped, and he received a diverted sentence. On October 31 of 2022, Mr. Topinka was terminated from the Oregon State Police after a complaint was filed alleging he violated Oregon State Police policies regarding truthfulness and code of conduct during his DUI arrest. On July 14, 2023, the DUI was dismissed as Mr. Topinka had completed the conditions of his diversion program. The department's review determined that Mr. Topinka did violate the board's moral fitness standards as follows. Dishonesty, Mr. Topinka was intentionally deceptive and misleading during his DUI arrest and personnel investigation. Misconduct, Mr. Topinka drove while over the legal limit of alcohol, which threatened harm to the passengers in his vehicle, pedestrians, and other drivers. Mr. Topinka left his vehicle during his DUI arrest, resisted and disrupted the Bend Police Department investigation, was placed in a patrol car to de-escalate his behavior at the Bend Police Department, resulting in multiple additional calls for officer backup. The totality of his conduct harmed the efficient operations of the Bend Police Department and brought harm to the reputation of the Oregon State Police and the police profession.
Thank you. Looking for a consensus to adopt the record?
Discussion, page 3 of 4, about a 5/8 of the way down. I think there's a typo. It says the investigative review of Topinka's body-worn camera shows that Topinka was asked to perform. I don't think Topinka was wearing a body-worn camera.
Jennifer Lavario for the record. We did correct that, and I believe a correction went out to the committee.
Oh, that's my bad then.
Yeah,
Thank you.
thank you for pointing it out.
Thank you for the correction. Okay, other than that, are we good with the record, or thumbs up, nod, something? Okay, looks like we have consensus to adopt the record. If there are any objections, no? Don't see any, so we will now discuss aggravating and mitigating factors. Scotty Downey for the record, I'll start. Aggravating factor, he was right downtown, it was on video when he went through the red light, there was 3 pedestrians. Had they stepped into the road, he would have ran him over. He was obviously not just driving intoxicated, he was driving intoxicated in a populated area with pedestrian traffic. There's lots of aggravating factors for this. He was dishonest in the amount of drinks he had. He was doing all sorts of things, like getting out of the vehicle, which he knows as a police officer is, a red flag for the officer. He was disrespectful during the entire process. I could go on and on. It's very difficult to watch and see that this is a police officer acting this way and putting these other officers in that position. He was extremely disrespectful through the entire process and was manipulating the process because he knows how the intoxilizer works, so he's doing things which manipulates the process based on his knowledge that he received as a state trooper in training for DUIs. Those are some of the aggravating factors that I found. Anyone else?
Rob Wood for the record. I concur with everything you said. He was definitely gaming the system. Evidenced by him telling, which was collaborated by his witnesses during their interviews, I got this, I got this, I got this. I know how to play this game is basically what he's saying. And he did play the game. He played the game with delaying the blood draws, with chewing gum, with, I think he was coughing. Great to know for future stuff, but yeah. It's, this amazed me, and this is a question for those certified at this committee session. Citizens have a right to refuse an FST, but Isn't there policies with OSP that they can't? That's a, no?
No.
Aren't, they're not? Okay.
The right stand.
The rights stand the same. All right.
It doesn't mean that's without employment consequence.
No, that's correct.
They're partitioned.
Okay. Yeah, I too can find no mitigating circumstances on this case.
Patty Lofgren, for the record, I would also add to everything you both said, the danger he posed to the passengers in his vehicle as well.
Online, anyone have anything aggravating, mitigating?
Barrett, for the record, you guys have covered a lot of it, so I don't want to get into it too much. Most DUI reports require one officer to write a report. Due to this gentleman's behavior, multiple people, to include a patrol supervisor, had to write a report. Kudos to Bend PD and their report writing. These were fantastic reports that I could visually see exactly how disruptive and problematic in gaming that this gentleman was, to a very, very noticeable degree.
Yeah, and Scotty Nine, for the record, also aggravating, just his incessant pounding on the door inside the jail. He knows how disruptive that is as a police officer, because when you go in there and folks that are doing that, it makes it very difficult to do work. He knew someone was trying to write a search warrant, and he's just incessantly pounding on the door, and when they would go see what he needed, just was confrontational, and it was, like I said, it was embarrassing to watch, knowing he was a police officer, and I think maybe I already said that, but it's just one thing after another. Even in his car ride, picking apart the way the officer's driving, and he's just, you would expect his BAC to be much higher. I think he claimed that he didn't remember what was happening. He ended up being at 0.14, which is a high BAC, but not something where I'm not going to remember what was happening. In my opinion, he knew exactly what he was doing. Based on what I was watching.
Shannon Anderson, somewhat mitigating is that I don't expect drunks to behave well. There's a reason that they're that we have rules around what you can do when you're intoxicated and what you can't. Your decision making, your coordination, all of those things are impaired. And so I guess I just, even as a police officer, if you are impaired, you are not going to make good decisions. So I tried to not take that to be more of an aggravating. It's just disappointing for me. But what is aggravating for me is that even when interviewed, there was not what I felt was taking responsibility for action. So even sober, there was, not my fault that they made mistakes, things like that. So.
Kevin Dresser, for the record, I was good to bring that up too, that his interview much later, obviously sober, and much later, he does take responsibility at times, but he's still critical of Ben's performance. And to me, that's kind of like missing the huge point here with really fully taking responsibility for reactions when he's still making these critiques of their performance that night. And that just didn't sit well with me at all.
Thank you. Okay, Jennifer, go ahead and recap.
Okay, for aggravating, he was down, while he was under the influence and in his vehicle, he was driving downtown. He went through a red light. There were 3 pedestrians at the crosswalk. It was populated. Had they been in the crosswalk, he potentially could have hit them. He was dishonest about the amount he did have to drink. He got out of the vehicle, which he knew as a police officer was not appropriate. He was disrespectful to the police officers there, which he knows is not appropriate as a police officer. He manipulated the DUI process, knowing what it was as a police officer, and I heard, in quotations, played the game. He delayed the process. This is part of the manipulation of the process. He chewed gum, he coughed, he was a danger to the passengers in his vehicle. Due to his disruptive behavior, multiple officers had to respond and write reports, including a supervisor. His incessant pounding on the door inside the jail, he knew that was, extremely disruptive to those police officers there. His blood alcohol level not being extremely high suggests that he knew what he was doing when he was doing these things. When he was interviewed during the internal investigation, he took no responsibilities for his actions, and he was sober at the time. And during that interview, he was critical of the Bend Police Department, which was
Shannon Anderson. The part about his blood alcohol level being not high enough to not have knowledge of it, I guess I would throw out for the group. Is it possible that he's not a heavy drinker, therefore that blood alcohol level would have behavioral changes that were consistent with what was happening? If that makes sense.
Got it down for the record. I would say his manipulation of the process goes to his mindset and his ability to think about how am I going to prolong this process, because as he's not drinking, his blood alcohol will eventually be going down. And I think everyone in the room knows exactly what he's doing, and I think it's not by accident that he was prolonging this. So I think his mental state by his actions says to me that that level of alcohol was not such that he, there would be someone who at a 1-4 could be falling down or passed out, but it didn't. To me, his actions were, he knew exactly what he was doing. He was cognizant enough to know what he was doing. That was my impression of what I watched. Anyone else?
Chair Downing, I do want to make sure I get the mitigating factors into the
Okay, sorry.
So for mitigating, I have, maybe we don't expect people who are under the influence to behave well. This could be a mitigating factor. Even if the person is impaired, they're not going to make good decisions. And then aggravating, we know that it's already been said that it's aggravating, perhaps, that because the alcohol level was low, he did know what he was doing, and the manipulation of the process kind of goes to that mindset, the ability to think that through. But also on mitigating is that perhaps if he's not a heavy drinker, that low blood alcohol level did impair his thinking.
Thank you. Consensus on the overview? Anything we need to add? Looks like we have a consensus. Okay, let's discuss the moral fitness violation categories. We can affirm, modify, or negate. And we have misconduct and dishonesty.
Shannon Anderson, I make a motion to confirm.
I second that. Patty Lochner.
We are voting on a motion to affirm the moral fitness violations. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren? Aye. Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, we need a motion to take action or no action. If there's a motion for no action, we need to include why.
Kevin Dresser, I make a motion that we take action.
Scotty Downing, I'll second.
Voting on a motion to take action. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarah?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren? Aye. Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, we need to discuss the ineligibility period. Length of ineligibility for this would be 3 years to lifetime.
Robert, for the record, I'm gonna put out there that we go 10 years for the dishonesty part of it. The dishonesty specifically, one of them is where he says he's had 2 beers. He was asked, have you had anything to drink today? I've had 2 beers at the Sidelines and Sports Bar, and in the video you see, that's it. He says that's it. It's not in the words here, but he says that's it. So he's not just gaming that he had those 2 beers at the last location. He said that's it, indicating that's all he had.
Is that a motion for 10 years? Other discussion or second the motion?
Kevin Dresser, I second the motion.
Megan, did you have, were you seconding or did you have some other?
I was just going to second the motion, but I think 3 of us tried to at the same time.
Mike, we are voting on a motion for a 10-year ineligibility period. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
This is 10 years?
10 years.
Nay.
Committee Member Barrett?
Aye.
Committee Member Sarek? Committee Member Sarek?
Or is it aye?
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Gardner?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Okay. We are. Chair, if I may just, Kathy McAlpine for the record, give you a very quick update so we can get you all out of here on time, but I think it's worth bringing it up. I just want to acknowledge that this was a heavy load, and even though we even removed a case, you had a lot. And I don't know if this is an indication of future to come where you're going to continue to get more and more video, body-worn cameras. I just want you to know that I will be cognizant of that as an additional workload when we're asking you to review these body-worn cameras, and that's a lot more to look at. So I just want to acknowledge that. Also, I think, thank you for your quick response. I believe now we've been able to determine that perhaps this was an isolated incident as far as accessing the videos, but we are looking for maybe even a more stable solution. So I'm working with IT, because again, as we continue to get more and more of these, and we'll also do a little bit better job of calling it out in the email that there is maybe a lot of video, or I think later Juan was able to say there's 9 videos for this person, 8. Really draw your attention to that. The only thing I might ask in return is in the early set when you get that, maybe just click on a couple just to confirm you're getting into them, and then you can go about it as your workday allows you to do. And then the director mentioned again on the POP packages and the personnel. I think what's might be notable to all of you is in there is an additional professional standards case coordinator. And again, as we're going through these and trying to get through the backlog, if we were successful, again, you guys can only do as much as you can with 4 in a year, but we want to make sure we're at least giving you guys a full agenda. And this one was, I would say, exceeded it, but we'll keep monitoring that. And Kathy, would you like any other updates?
Yeah, I'll be brief. Kathy Fink for the record. Just wanted to share with you, I know and I appreciate the recognition of the hard work that the team does. And what you see in here is the part of our team that does professional standards, but we also do certifications and scheduling and such. And so the whole team has been working hard on some outreach. And during that, as they're doing that, parts of the teams have gone out to Klamath Tribal Police to help them with getting established and getting their processes put in place and understanding how we operate and how we how we can benefit them in getting things established well. I did that in May, I think it was like the day before we had the committee, so I can't remember if I mentioned that or not. Since then, the whole team put together a virtual presentation that we did, had really good turnout for that, spent a lot more time on each of the sections, allowed some opportunity for questions about some of our forms and things like that, which I think is beneficial to understand more of who we are, what we're doing, kind of all this behind the scenes stuff. And then just this week, we went out to Warm Springs PD to also help with that. And one of the things that I appreciate that the team enhanced was about the moral fitness things. And the presentation was really heavy on the scheduling and certification, and now it's more kind of evened out and has a lot more information about professional standards and kind of the work that they're doing with that. Other than that, we've been doing some changes and updates to some forms, so you'll probably see a CJ update come out soon regarding that.
That's it. Thank you so much.
Thank you.
Sorry, gotta pick up kids.
You want to adjourn it? We're good.
Okay, we can adjourn. No one else has anything.
Thank
you very much.
Thanks, Police Policy Committee meeting is going to be held on November 21st at 10 a.m.
Okay, thank you.
Good reminder.
Oh.